Good morning, Your Honor.
All right, good morning, everyone. We're going to go ahead and get started. This is the state all-purpose calendar in the State Court of Fulton County, Georgia. I am Judge Melanie Williams, and today we will address a variety of matters, including taking pleas, arraigned cases, and set bonds as necessary. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. This particular proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch this proceeding. Have all member, where are the public defenders? Are they at the jail?
Your Honor, I just got an email from PD Vigiletti that she sent to the court and to everyone, letting them know that they're apparently having delays at the jail, and the courtroom is not, there's no one currently in the courtroom, and so they think there may just be some unexpected delays.
Okay, so we'll hold, and I may have to say that announcement again,
Understood.
unfortunately. Thank you, Ms. Falk.
Your
Good
Honor,
morning.
good morning.
Yes,
How
good morning. Good to see you.
Same here. If it's possible, when they come on, can ACDC go first? Because I have a 9:30 calendar with Judge Cox.
Yes, that should be fine. Only problem is, have your clients been interviewed? I mean, not your clients, but have they been interviewed by the public defenders already? Do you know? I don't know if we're gonna make 9:30 then.
Okay, so if I leave out, I'll be coming back.
That's fine.
Uh, Your Honor, if you don't mind me asking, ACDC, can you tell me which individuals are there? And I think I should be able to tell you if they met with them.
Okay, position 9 and 10, Hamilton.
Uh, that's going to be not guilty in a bond request.
Position 16, Jabrika Mayana.
There was a request for a conflict attorney, so I'm not sure if that attorney has met with the defendant yet.
Everybody was shaking their head no, so I don't think so.
Okay.
Okay, hold on, ladies. We got this. Position 22, Britangela Neal.
That's announced as a negotiated plea.
Position 35, Joanna Ware.
That's announced as a negotiated plea.
That's it.
Okay. So it looks like, for the most part, with the exception of maybe one or two people, the PDs
They've had the opportunity to speak. Is Miss McLeod here today? No.
I know that Miss Vigiletti
Miss-
made a request for a conflict PD.
hold on 1 second. Miss Watson Cafe, do you represent who was the one for the
I represent Neil Salter.
Oh, okay.
It's Jabreka Mina. I may be mispronouncing her last name, but
Okay.
position 16.
16 also needs a conflict attorney, Jabreka Mina. I don't know if Miss McLeod has already been assigned to that case. Miss Watson Cafe, would you be interested in speaking to that defendant to see if you can assist her today? She needs a conflict attorney.
Yeah, I could do that.
Okay. Is there a number that Miss Watson Cafe can call?
Yes.
I'm ready.
404
Mm-hmm.
865
Uh-huh.
8122.
Okay.
Okay.
And what's the client's name again? I'm sorry.
Her last name is spelled Maina. First name is spelled Jebreaka.
Okay. Thank you.
Ms. Falk, do you want to chat her, Ms. Watson Cafe or send her an email with the offer?
I will, Your Honor.
Okay.
Can you send me for Neil Salter too?
Of course.
Thank you.
All right, I see courtroom 2 has logged in. Is anyone at courtroom 2? Okay, we'll continue to hold. Thank you.
That's it, the second row.
Legal lady.
Everybody. So we're good. Good morning, Judge Williams. I apologize. I sent an update to Judge Law this morning.
That's okay. Good morning. Have you had the opportunity to interview your clients?
Most of them, I have a few more that I need to speak with, particularly Mr. Smith here, who's on the screen from Oconee. But we could get started. I do have a number of clients who are ready.
Okay. All right, I'm gonna repeat myself because you all at courtroom 2 did not have the benefit. Good morning, everyone. This is the State All-Purpose Calendar. I'm Judge Melanie Williams, and today is April the 9th of 2024. At this calendar, we will address a variety of matters, including set bonds, take pleas, and arraign cases as necessary. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. This proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this proceeding. When I ask if you understand your rights, that is what I am referring to. All right. Who do we have first?
We can go with writing.
Oh, wait a minute. Forgot. We had a request for ACDC to be able to go first because there was a 9:30 conflict. Are you able to start with the cases at ACDC?
Yes, Judge, I do have a witness coming, so I'm gonna shoot them a quick text, let them know we're starting with ACDC, but yes, I'll be ready in just one moment.
Okay.
We can start with position 9 and 10. Ms. Hamilton. Does she come have a seat, please?
Okay. Ms. Hamilton, you have two cases, 19 CR 003619C. In that case, you're charged with simple battery. And the other case, 20 CR 004786G, you're charged with battery family violence. Do you understand your rights today? Is that a yes?
Yes, ma'am.
All right, thank you. And the announcement I have is that this one is waiver arraignment and we're gonna need a bond hearing.
Yes, unless anything has changed, Ms. Hamilton, we're
Yeah.
doing a bond request this morning, right? Okay.
Ma'am.
All right, are you asking for formal arraignment? Or are you gonna enter a waiver of arraignment after court today?
I'll file a waiver after court, Judge.
Okay, thank you. All right, give me one moment. Is this the case in which we're waiting for the witness?
And he is here with us. Mario Edwards is here on behalf of Ms. Hamilton.
All right, Ms. Falk, please proceed. And if you tell me the current bonds too.
Yes, Your Honor, I'm pulling that information up now. So the current bonds on the family violence battery, which was the 20 CR 004786, which is position 10. The defendant received a bond in the amount of, let's see. Okay, that can't be right. The bond amount said 250,000. It was actually, let's see, 2,950. She bonded out back in September of 2020, and then she failed to appear for a plea and arraignment on December 8th of 2021 before Judge Mather, which resulted in a bench warrant for her arrest. The other case, which was the 19 CR 003691, the defendant failed to appear July 8th of 2021 before Judge Dixon, and a bench warrant was issued for her arrest on that date.
Okay.
See, the bond currently that she's being held on both of these cases, because obviously the bonds were revoked, is an amount of, let's see. She's currently being held on no bond, actually, on both cases. And technically would not be entitled to a bond because of the fact that she was issued a bond and then the bonds were revoked because of her failure to appear. So as far as the actual underlying charges on the simple battery, it's
Hold one
alleged.
second, Ms. Falk. In light of that no bond situation, Miss, I'm sorry, please tell me your name again. I've forgotten.
Yeah, no, I don't think we've actually met before. I'm Olivia Vigiletti.
All right, good morning, Ms. Vigiletti. In light of the fact that it sounds like your client would not be entitled to bond, do you want to speak to her again about the state's offer?
I can, Judge. I will say that the arrest warrants for her failure to appear do have a recommended bond on them from the judge. But if you're not inclined to grant a bond today, I can certainly have a discussion with her.
I think you should have a discussion with her, and if you would send, I'm operating at a loss. Remember, Judge Law was supposed to be here. Normally, I've looked these things up. If there's any way to send me those recommended bonds, Ms. Falk, or
Yes, I can send them to you as well, Ms. Fox.
Yeah, I'm looking at the face of the bonds now. She is correct. I don't know why it said no bond in the system, but
Okay.
on the simple battery, the recommended bond is $5,000 surety. On the family violence battery, the recommended bond is a $2,000 surety. And yes, I will send those over.
Okay. We'll still hear bond arguments, and then maybe we can speak to her to see if she still wants to consider. But please proceed, Ms. Falk. I apologize for interrupting.
Okay, so in the first instance, the kind of going back to my other screen, just a moment. So in the family violence battery, it's alleged that she caused visible bodily harm to Mario Edwards by punching him. In the second case of the simple battery, that was a simple battery against Miss Simone Alexander, and it's alleged she punched her in the face. I will also say that there was a case that was placed on the dead docket, 19 SC, let's see, 165536, and that alleged that she committed an assault on Mario Edwards, who is the victim in our family violence battery case, by cutting his hand with a knife. And so that was then presented and placed on the dead docket in the felony case. So there is a history here, Your Honor, between her and Mario Edwards of violence that resulted in at least one felony charge and one misdemeanor charge. In addition, she has 9 cycles altogether. There is cycle 1, which is that 2018 case for aggravated assault. Cycle 2 was an arrest for simple battery. Cycle 3 is the failure to appear on the aggravated assault case because she failed to appear on that case too, which makes for 3 failures to appear. Cycle 4 is a failure to appear on the simple battery case. Cycle 5 is the family violence battery case. Cycle 6 is another family violence battery case. This one's out of Dunwoody, so that's going to be a DeKalb County case. Cycle 7 is a failure to appear on that family violence battery case out of DeKalb in 2024, March of 2024. Cycle 8 is a failure to appear, another failure to appear on one of our cases, and cycle 9 is a failure to appear. So essentially, her entire history is either domestic violence, or failures to appear.
I am going to hear, first I'm going to sound for Miss Alexander. Is Miss Alexander present and wishes to make any statement? Okay, Mr. Edwards, if you would like to make a statement, please raise your right hand and unmute your screen. And turn your camera on. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yeah.
All right, what would you like to tell me today?
Well, I would like to say that me and Davina are not romantically involved. We haven't been involved with each other probably in a few years, but we do maintain our friendship. And I just feel I don't have any issues with her. Like, me and her are really good friends. a lot of the stuff that happened was like stuff in the past or whatever. But you know, I don't have a problem with. I don't think that she deserved to be locked up without a bond. I mean, she has lost her job because of these warrants, and you know, went through a traumatic phase last year that she had to go through. You know, with the loss of a child, and I mean, it's just been a lot. But I mean, being held with no bond, I feel is definitely unfair. And again, we're not together for us to have any issues as far as any fights or anything like that. We've moved far past those stages. You know, though she was a lot younger when she was getting into those fights and stuff. So, um, I feel she should be granted a bond so that she can get out and do what she needs to do as far as seeking employment, and being a productive citizen.
All right, thank you. I appreciate you coming to court making that statement. Ms.
No problem.
Vigilante, please proceed.
Your Honor, if I may just ask Mr. Edwards one question.
Very
Yes, ma'am.
briefly, Ms. Falk. Ms. Edwards, turn your camera back on, and reminder, you are still under oath.
Mr. Edwards, hi. The incident that happened in DeKalb County in 2020, did that involve you as well?
Yeah, it did involve me. But I had got it. It was really a verbal argument. But when the police came out there, they were like trying to push this whole narrative, and I was trying to explain to them that that's not what happened. But they didn't care anyway. They just locked her up on Christmas. But there was no physical altercation that day at all.
But just to clarify, there have been 3 separate times that the police have charged her where you were the victim.
Yes. Yeah, I just answered that question. Yes, I have been a victim a few times, misunderstandings. But I'm not a victim. I don't, you know, like I said, I don't have no problems with her. We haven't been involved with each other like that. We're not in a romantic relationship. That's my friend. She's a good person. She's changed her life in so many different ways. And it's just sad to see her on the screen like this today. It really is.
Thank you, Mr. Edwards.
You're welcome.
Ms. Vigilante?
Yes, Judge. I spoke with Mr. Edwards yesterday. I also spoke with Ms. Hamilton, and largely I'm going to echo what Mr. Edwards said. Both of them tell me they haven't been together in about 3 years. They had an unhealthy romantic relationship, but as friends, they seem quite healthy, quite supportive of each other. Ms. Hamilton is a changed person from what we're seeing in 2019 and 2020. She did, as Mr. Edwards alluded to, experience some very traumatic things. She lost her daughter tragically. And you know, as we all know, sometimes trauma can trigger making a lot of changes in your life. So Ms. Hamilton has since moved to Savannah. She is relating to her community in a much healthier way. She's a store manager at a store called All Starting League. She's, you know, grown up and responsible. And I do believe if she understands that nobody wants to hear, you know, somebody rattle off all of these failure to appears, I do think she has every motivation to come to court and get these taken care of in a timely manner going forward if she is granted bond. But, you know, because she does have this job and this life that she's worked so hard to set up for herself, you know, pretrial detention puts her at great risk of losing that.
Okay, I'm gonna take a quick look at the bonds that Ms. Falk sent over to us. Okay. And she does have a stable address registered with the court, Ms. Vigilante, to make sure that she's gonna be at all future court dates.
She has given me that address and an updated phone number, so I can update the court with those.
Okay. And will she continuously qualify for your services at the public defender's office, or in light of her job, will she have to get other counsel?
You know, Judge, I'm actually not sure. When folks come to SAP, we don't bother with the application. So we'll have to assess going forward.
Okay. All right, I will go with the recommended bonds that appear here. Were there other special conditions on these bonds? No contact or anything of that nature, Ms. Falk? Or in light of the age, we're not requesting that?
No, the state will be asking for no contact with Mario Edwards and stay away from no further contact with both Mario Edwards and Simona Alexander and stay away from their addresses. For Miss Alexander, it would have been 1117 Metropolitan Parkway, and I'll need to pull up the one for Mr. Mario Edwards.
If you would just chat them to Miss Grace, that'd be great.
Will
All
do.
right, we will go with the recommended bonds. It'll be 2,000 on the what was that, the simple battery, and 5,000 on the battery family violence. She's to have no contact with either of the alleged victims during the pendency of this case, and she is to have no alcohol, no drugs, no weapons, and stay away from both of those locations. Is there anything additional from either the state or the defense?
No, Your Honor.
All right, Ms. Hamilton, best of luck to you. Take care.
Thank you, Judge.
All right, can we take the next position at ACDC?
Next, we have position 22, Ms. Neal.
Okay, I have that this one is a negotiated plea, is that correct?
Yes, Your Honor.
Okay, Ms. Neal, let me turn and do this correctly. All right, good morning, Ms. Neal. Your case is 24 CR 00158 in this case, you're charged with hit and run, DUI, open container, endangering a child by driving under the influence, and having an expired license. Do you understand your rights this morning? All right, thank you. Ms. Falk?
Yes, Your Honor. On count one, the state's recommendation is going to be 12 months to run concurrent with count three, a $135 fine. On count two, the state's recommendation is 12 months to run concurrent with count three. And on that case, the fine will be $300. Count three, the DUI, the recommendation is 12 months served, 32 days, credit for time served, 16 days. That's going to be from 4/28 to 5/13 of 2022, balance probated, a $300 fine, 40 hours of community service, ADET, DUI risk reduction and victim impact panel. On count four, the recommendation is 12 months concurrent with count three with a $265 fine, and count five, the recommendation is 12 months concurrent with count three and a $1,000 fine. That's going to be a total of 12 months served, 32 days, credit for time served, 16 days, balance probated is $2,000 in total fines, 40 hours of community service, ADET, DUI risk reduction and victim impact panel. This incident, just to give Your Honor the brief facts on this case, occurred at April 27th of 2022. Officers were flagged down by a silver Chrysler who stated she was struck in the parking lot and was giving chase. A female driver exited the vehicle and fled the scene. Officers were able to stop the vehicles, detained. Miss Neal smelled the odor of alcoholic beverages coming from her person. She was staggering unsteady on her feet. She reached into the rear passenger side of the vehicle and retrieved a 4-year-old small child. And that was the basis for these charges. The state would ask the defense to stipulate to venue factual basis and identification for the purposes of this plea.
We do for the purposes of the plea.
And that was your understanding of the offer?
Yes, it was, Judge.
Okay, oh, I'm sorry, go ahead.
Oh, I was just gonna add that I spoke with Miss Neal yesterday. She talked about, of course, being embarrassed by this incident and did want to let the court know after this, she enrolled herself in a parenting class, and was actually on her way to already enrolling herself in the risk reduction, when she was picked up. So I think she'll do very well. I don't think we'll see her again. I did also just want to note that an FTA was opened, but it's not on the calendar. So I just wanted to give the court that case number if we could note cross that. It's
Oh, yes, please.
it's 22 CP 208627.
If it has a CP number though, can I know?
Yeah, this was initially charged as a felony and then was bumped down. So the FTA is open with that felony case number. I'm not quite sure what to do with that.
Neither am I, because if it has a CP, I don't think we can no process. Can we, Ms. Falk? I don't think you can. If it has a CP number, does anyone know? Ms. Lewis?
Well,
do you
if-
know?
I think the
Okay.
solution is if it was transferred to state court, I don't know where she garnered the bench warrant. If it was at the time, let me just take a look, because if she got the bench warrant while it was a felony, then no, we can't rectify that. But if she got the bench warrant once it was transferred, we can.
Okay.
So let me just check that out while Your Honor is addressing the other matters.
All right, that's fine. We'll look into that because I don't want her to have to stay if we can take care of that. Ms. Neal, I need to ask you some questions to make sure this is a voluntary plea, okay? Please raise your right hand. I'm going to place you under oath for the brief and limited purposes of taking this plea. Do you swear and affirm the testimony you give today be the truth to the best of your knowledge and under the penalty of perjury? Is that a yes?
Yes, ma'am.
All right, thank you. Put your hand down and speak as loudly as you can. We want to make sure that you want to take this plea, okay?
Yes.
Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand that taking the plea, you're not going to have any further court dates.
Yes, ma'am.
And you're giving up your right to trial by judge or jury.
Yes, ma'am.
And you further understand all the requirements. Have they been fully explained to you by your attorney?
Yes, ma'am.
You understand that you have courses to take and fines to pay, as well as some community service.
Yes.
And you are satisfied with your attorney's representation?
Yes, ma'am.
All right. As to the charges I previously listed, Ms. Neal, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional, Ms. Vigiletti or Ms. Falk?
No, Your Honor, but it looks like, and I'm just double checking one more thing, and then I can give Your Honor an answer about that bench warrant. It looks like this case was actually declined and transferred March 9th of 2024. After the case was declined and transferred, the pretrial came off the bond and issued a bench warrant on March 10th of 2024. So it looks like literally the day after well, I take that back. They issued the bench warrant March 10th of 2023, a year before it was transferred.
Okay.
So now it is technically now, I don't know if pretrial supervision can then just,
It will be up to pretrial to do that dismissal.
okay, right.
Services will have to do that dismissal because they
So-
the one that issue out the bench warrant, and it's a pretrial warrant, so it will be up to
Okay.
pretrial
Is
services.
anybody from pretrial on here now that can tell us whether or not they'll be willing to do that? Oh, Ms. Tyson, is
Good
that something that you can take care of?
What's the question again? I'm sorry. What is it?
She has a pretrial bench warrant for a failure to appear. She's taken a plea as to the underlying charge. So we're trying to figure out if we can have that I guess bench warrant or FTA no pros. Am I saying it correctly? Or dismissed? Dismissed.
And I just sent you over the bench warrant, Ms. Tyson, so you can take a look at it. It looks like pretrial issued the bench warrant about a year before it was transferred down.
They did.
Okay. I'll have to ask and probably send it to someone because I've never had to, if they take a plea, I've never had to null process the bench warrant or anything. So I just received it. I'll send it to someone and see if that's what we have to do because I've never had to do that.
If you could look into it so we can figure it out before we finish, we'd
Okay.
appreciate that.
Okay, I can.
Ms. Lewis, you were gonna say something? I'm sorry.
No, I was telling her she can talk to her supervisor, Ms. Joy Manor. She's aware of these warrants because I'm familiar with the pretrial warrants. And normally, if the underlying charge is the FTA that pretrial it will be your responsibility to do a dismissal and have the judge sign off on it.
Okay, all right. I'm gonna go check with her right now.
Okay.
Thank you.
Ms. Neal, I will come speak to you after court just to confirm that this is taken care of, okay?
Yes, ma'am.
All right, Ms. Neal, we're working on that. Best of luck to you, okay?
Thank you.
All right, can we take the next position at ACDC?
Yes, position 35, Ms. Joanna Ware.
Okay. Good morning, Ms. Ware. Let me
Good
look
morning.
at one thing really quickly. All right, let me make sure. The announcement I have for Ms. Ware's case is that this is a negotiated plea.
Yes, but if it's possible to speak with her for just 1 second, there was something I wanted to look up for her last night and I did find some more information.
Okay, are we able to give, can we give a call over to ACDC? Oh, do you need to leave?
No, I'm waiting for, Ms. Mayna to come off the phone so she can talk to the attorney.
Okay, I understand it's 9:30. Do you need to be in Judge Cox's courtroom?
What I'm gonna do is finish up here quickly and then log on because I don't know what position those two ladies are on his calendar.
Understood. Okay, so,
Which,
we'll come back to you, Ms. Ware.
have a seat. I'm gonna call courtroom 2 right now.
Okay. And who's in the chair?
Position 16, Ms. Watson Cafe is handling this one.
Okay. Is Ms. Watson Cafe back? She's not.
Judge, perhaps while we're waiting, if I join the Zoom, ACDC and I could enter a breakout room so I could speak with Ms. Ware briefly.
She's calling the phone.
Oh, okay.
I'm gonna call you.
She's on.
Oh, I'm hoping Ms. Watson Cafe comes right back.
I'm calling courtroom 2 right now so Ms. Vigiletti can talk to Ms. Ware.
Okay, that's perfect. Thank you.
Excuse me, Judge.
Yes, ma'am.
Can you check your chat for me, please?
Oh, okay.
Thank you. And Judge, I'm sorry, that was for position 9 and 10.
Okay, I got you.
So they're going to remain from what they currently were?
Yes.
Okay, so we're just going to go to not guilty. Thank
Yes.
you.
Your Honor, just to ask while I'm here, do you prefer that we put the facts on the record or just ask the defense to stipulate to the factual
I
basis?
do. Unless they're sensitive facts, it helps me
Okay,
when they're
not a
actually.
problem.
You're pretty good at doing them quickly, Ms. Falk, so.
It was- I just want to make sure I pull them up so I'm ready to go.
Not 30 minutes of facts, of course, but
Got it.
some people I prefer the stipulation. Oh, is Ms. Watson Cafe coming? Is she here? There's nothing else we can do in the meantime, is there? Nope.
Your Honor, if we have a spare moment.
Yes, good to see you, Mr. McLean. Good morning.
Good morning. One of my 2 probation matters today is last name O'Malley.
Uh-oh, okay.
And I've determined from an interview yesterday, it was reset in order to find out certain facts. But it turns out once I did the interview, that case is not ready to go forth, and I can, in confidence, in a confidential way, either in a breakout with the court and the state or by chat. Well, not by chat, that's visible to everybody here. I can explain why that's not ready for today, and we would need to put that on another day. I'm going to make a referral.
Okay.
Thank you.
Well, let's see. I don't know that I've received the probation calendar. Let me go and get it. So that will be helpful to all of us. Give me one moment.
Right. I'm going to have certain interviews and evaluations done.
Okay.
Now,
And Your Honor, I
You're here. Oh, good. Yay. All right. Can we take your client's position? I've since forgotten who she was. I'm sorry, Ms. Watson Cafe. Remind me again who your client was?
Maina, Maina.
Okay, Ms. Maina. Ms. Maina, your case is 24 CR 001581B. In this case, you're charged with theft by shoplifting. Do you understand your rights today? Is that a yes?
Yes, ma'am.
All right, thank you. Ms. Falk, please proceed. The announcement I have is, what is the announcement? Let's go with the announcement. What is this gonna be, Ms. Watson Cafe?
Enter a plea of not guilty.
Okay,
We do have the offer.
okay. Do you wish to be heard on bond?
No, I believe a bond is already set.
Okay. And
Well,
you'll
can we
be,
check that?
is
My
there a
understanding the
bond?
bond is set.
There is in the amount of $1,228.
Okay,
I'm literally just reading off the jail screen. I don't know why
Okay.
that particular amount was set. It
That
looks
was-
like it was a bind over from municipal court, and that was the bond set by the Municipal Court of Union City.
okay, I'm sure there was some reason. Okay, so you're gonna enter formal arraignment after, formal waiver after court, Ms. Watson Cafe?
Yes.
All right. So Ms. Maina, your attorney is gonna work and do further development on this case. She will be in touch with you. She's gonna enter a not guilty plea for you at this time. You do have a bond that you could make on this particular charge, so your case will be reset, all right?
Thank you.
All
And-
right, take care.
Your
Anything-
Honor, just in an interest of candor with the court, I will say that Ms. Maina has about 5 or 6 prior convictions for theft by shoplifting, so we will be seeking to transfer this to the DA's office.
Oh, okay. Do you want to put the offer onto the record too at this point?
Yes. The state's offer, which we are revoking, is 12 months probation, serve 180 days, credit for time served 12 days, balance probated, a $500 fine, anti-theft course, and stay away from the Walmart at 4735 State Route 138 in Union City. And I did advise Ms. Watson Cafe, I know she joined on this case with very short notice, but I did advise her that there were about 4 or 5 previous convictions for theft by shoplifting that this defendant had. We just have to get them from the other counties where she gathered them.
As it pertains to this particular case, what was the value of what she took?
In this particular case, clicked on
Or
her.
allegedly took, allegedly.
Right.
Excuse
In
me.
this particular case, the value of the items that she was alleged to have taken were $16.10. She entered the Walmart and took a number of items along with another individual who she was arrested with.
What was the, do we know what the items were allegedly?
I'm checking. Let's see. It states stolen merchandise, but doesn't specify which items.
Okay. Ms. Watson Cafe, is the concern that your client had the additional jail time?
Yes.
Would you like to consider a non-negotiated plea?
I can't. I can, yes. I just need, I need to know if she willing to consider that.
Okay, I know I'm holding up ACDC. Would you like to give her another quick call?
Yeah, I'll make it quick this time, Your Honor. I was
Okay.
just trying to
it's
get some preliminary
I
information.
know you have a lot going on and we gave this to you at the last minute, but if we could address this today, I would like to consider it. Okay?
Okay, I appreciate
Okay.
that. Thank you, Your Honor.
Okay, and does she have a stable address?
Yeah, she gave me an address, yes.
Okay. Okay. All right.
All right.
Let's
Thank
take
you.
Ms. Ware's case while Ms. Watson Cafe makes that discussion. All right. In this case, Ms. Ware, your case is 24 CR 001584H. You're charged with DUI under the influence of alcohol and drugs. Do you understand your rights?
Yes.
All right. I have that this is a negotiated plea.
Yes.
Yes, Judge, and I actually haven't done this before, but Ms. Ware is highly interested in DUI court, doing her probation through DUI court. So I was wondering, Ms. Falk, I don't know if you can shed some light on whether that's possible and how we might get her into that program. She did check herself into Ridgeview after this incident. She's been working with a sponsor. She's very motivated about her sobriety. So I think she would be a good fit. I just don't have a lot of experience with referring folks there.
I am texting the person who handles that now to look at this case and let me know within the next 15 minutes whether she would be eligible.
Okay, that's
Okay.
thank you so much.
So we would still need to wait though to take the plea, correct? See if-
Yes, Your Honor.
Okay. Okay, so we're gonna have to hold for Ms. Ware for a moment. Is that okay? I know you have to leave at ACDC. Can we have the 15 minutes?
Yes, Your Honor.
Thank you. I appreciate it. This court has a lot of moving parts.
Yeah.
All right, we're waiting for Ms. Watson Cafe to come back. Is there another matter we can take in the meantime?
We can go to position number 5, trying to be low.
Okay, give me 1 second. Okay, the announcement I have for position 5 is that this is gonna be a not guilty, is that correct?
Yes, Judge.
Okay, and are we being heard on bond?
No, Judge, Mr. Deloach has holds for other incidents. I wanted him to come to court today because I had some updates on him for something else. But he is entering a not guilty plea today, and I will send over a waiver of his formal arraignment.
All right, Mr. Deloach, your case will be reset. Your attorney is gonna do some further work on this case. So, she'll speak to you and give you further instructions, all right?
Thank you, Judge.
All right, best of luck to you.
Next, we can go to position number 7, Tahaj Jackson.
I'm ready, Your Honor, on
Okay.
Ms. Maina.
Okay, can we go back to ACDC very quickly, Ms. Mena? What's your announcement, Ms. Watson Cafe?
She does want to do a non-negotiated plea.
Okay. All right, so Ms. Falk, if you'll put the brief facts onto the record in the state's recommendation.
Yes, Your Honor. On August 20th, 2023, defendant entered the Walmart at 4735 State Route 138, stole $16.10 worth of merchandise, along with a co-defendant named Mark Beatty. The state's recommendation, based on the fact that the defendant has at least 4 to 5 prior convictions and then 2 pending felony theft by shopliftings in Superior Court, is 12 months served, 180 days, credit for time served, 12 days. That's from March 29th of 2024. Balance probated, $500 fine, anti-theft course, stay away from 4735 State Route 138 in Walmart, and that's in Union City. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this non-negotiated plea.
All right, do you so stipulate, Ms. Watson Cafe?
Yes, we stipulate.
All right, and your recommendation for being considered?
We would recommend 12 months probation. The anti-theft course on the stay away is fine as well. And restitution in the amount of $16.10 as opposed to the fine. She has a, I think based on the amount that is alleged, or that based on the amount, Your Honor, I just think that would be, based on the resources of state, holding her in jail for 180 days on this case. We just don't kind of believe that would be overkill. In addition to that, the $500 fine that is going, my understanding is that she does not have stable income that would be able to assist in that. If Your Honor, I believe the restitution would be sufficient to $16.10. If Your Honor is not amendable to getting rid of the fine, we would ask that it be converted to maybe community service hours, or to allow her to do community service for the hours that she cannot, for the amount that she cannot cover.
Okay. If, how much time, Ms. Lewis, how much time has, or Ms. Grace, how much time has she actually served on this charge?
Your Honor, that's 12 days from March 29th,
It's been in
2024.
12 days.
Yes.
Okay.
Okay. And I
So,
will point out that the fine is statutory. The state didn't just arbitrarily choose it. It's part of the statute that because of her previous convictions, it is a $500 fine.
Okay. All right. If defendant takes this plea today, what we would do would be 12 months on probation, 24 days to serve, credit for time served 12 days. I would convert the fine into community service. I never know that equation. What is the conversion of what is it, 50 hours?
It's normally 10 hours per
10
$100.
dollars. Okay. So I would convert that into community service. She would still have to take the theft course and stay away from that Walmart. Does your client wish to take that plea, Ms. Watson Cafe?
Ms. Maina,
Yes.
She
do
does?
you want to take that?
Yes.
All right. So I'm going to place you under oath and ask you some questions to make sure that this plea is voluntary. Please raise your right hand. Do you swear and affirm the testimony you give today for the very limited purposes of taking the plea will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
I am.
Did anyone promise you anything in exchange for taking a plea today?
No, ma'am.
And you understand that taking the plea, you're not going to have any further court date as it pertains to this particular charge?
Yes, ma'am.
You're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you further understand that taking a plea may affect any of your open cases, probation, or aspects of employment or other things that either I or your attorney may not be able to anticipate? Do you
Yes.
understand that?
Yes, ma'am.
And you further understand the requirements that you're gonna have to do community service and you're gonna have to take an anti-theft course, and you absolutely cannot go back to that Walmart in Union City. Do you understand that?
I do.
All right. As to the charge of theft by shoplifting, Ms. Maina, how do you plead?
Not guilty. I mean, guilty, sorry.
Are you sure you wish to take a guilty plea today?
Yes.
Yes, we have to be sure that that's what you want to do. So as to the charge of theft by shoplifting, how do you plead?
Guilty.
All right. I accept your guilty plea at this time. What about her paperwork? How will we get that completed? She's gonna have to sign. Any thoughts?
I mean, I can the paperwork be sent to me? Ms. Maina, well, Your Honor, would you be amendable to me signing on her behalf if I have authorization from her?
As long as she gives you express permission, I think that will be fine.
Okay, Ms. Maina, do you authorize me to sign on your behalf any paperwork related to the plea?
Yes.
Okay, thank you.
All right, so Ms. Falk, if you could perhaps send some paperwork to Ms. Watson Cafe so that we can get it closed on out.
Got it.
All right, Ms. Maina, I've given you somewhat of a second chance, all right?
Thank
Best
you.
of luck to you.
Thank you.
All right,
Judge, how many hours of community service?
I'm bad at that math.
50.
Please don't make me do that.
It's 50.
50.
It's 50 hours.
Okay, thanks, you guys.
Don't call me out like that anymore, Miss Grace. You chat somebody.
Won't do, Judge.
Do not. I purposely did not try to calculate that. All right. Back to Miss Ware. Were we able to resolve that, Miss Vigiletti? Oh, Miss Vigiletti is not there. Oh, there she is. All right. Have we resolved everything as it pertains to Miss Ware? Oh, no, we were waiting for the DUI referral. That was what it was.
Yes.
And we didn't get that
I'm
information
still
yet.
waiting. I haven't received a response yet.
Okay, well, Ms. Ware is the only one left at ACDC. If ACDC wants to drop off and come back, that's possible too.
I will, thank you.
Thank you. All right, who do we have? And Ms. Watson Cafe, oh, you still have one other case. So are we able to take,
Alter.
are we able to take
Uh,
her, that position, Ms. Watson Cafe's other case?
Well, I need to communicate the plea to him, if possible. If I can have a phone number to call.
Is Mr. Salter at courtroom 2?
Yes.
Can Ms. Watson Cafe give him a call? All right. Is there another position we can take in the meantime?
Do I have people on it?
Miss what? What's that?
Mhm.
Miss Watson, my face on it. She's gonna call that number.
Okay. Let's switch it on then. You got it?
I have it.
There was some call.
I'm Mrs. Salter. Okay, my bad.
Excuse me. All right, is there another case that we can take up?
We can go to position number 1, Mark Batty.
All right. Good morning, Mr. Batty. Your case is 24 CR 001580B. In this case, you're charged with theft by shoplifting. Do you understand your rights today?
Yes. I mean, I don't think that-
All right, the announcement I have is that this is a negotiated plea.
Correct, Your Honor.
All right, Ms. Falk, please proceed.
Yes, Your Honor. Sorry, I was working on the plea paperwork.
I
Where
know.
are we on this one?
No, it's been we're asking a lot
I
of you
know.
this
Which
morning.
number is this, Your Honor?
Position 1, we're gonna take a
Okay.
negotiated plea for Mr. Batty.
Position number 1 is 12 months, served 22 days, credit for time served 11 days. That's going to be from March 29th, 2024 to today. Balance probated, a $500 fine, anti-theft course, stay away from 4735 State Route 138 in Walmart in Union City. If this sounds familiar, it's because it is the second half of the other case, which involved Miss Mina. On the defendant also has an open 2024 000764 theft by shoplifting case. We're recommending 12 months probation concurrent with the previous case, and a stay away. That's also going to be balance probated, and a stay away from 3730 Carmia Drive Southwest, which is the Publix. So I do have the question of whether this is being taken as a global recommendation on both cases or just the one.
And I have an additional question. Did we already do the Publix case or is it open indeed?
My understanding is that both cases remain open. Let me just double check. Let me just double check. Yeah, I'm showing both cases are active and open.
So it'll be a resolution of both, I'm assuming. Is that correct, Mr. McLean?
That would be the state's recommendation, yes.
Yes, if they're both open, we just didn't have time between the question coming up yesterday and this morning to check the computer. He was under the impression he'd already taken care of the Publix case. I do remember the address coming up, but the address Carmia Drive comes up fairly often. And it may be that we started a plea and didn't finish it. That's entirely a possibility too. So we can take care of both today, and if one's a duplicate, I'm sure we can figure that out later.
Okay.
And Your Honor, just briefly, that case involved the defendant taking $254.43 worth of merchandise, including household items, including laundry detergent and poultry. The state would ask the defense to stipulate to venue factual basis and identification for the purposes of this global plea.
Yes, we do so stipulate for the purposes of the plea. He is reminding me, he's saying, I definitely got 12 months probation on that other, so we definitely do need to look that up.
Okay, I'm gonna go and look because he was on the SAP calendar previously, so I'll go and look that up while we address
we
the
have
rest of
questions.
this.
Okay.
All right, and you did, and that was your understanding of the offer, correct, Mr. McLean?
It is, Your Honor. We discussed both of them last night.
Okay, perfect.
I
All
should
right,
say-
Mr. Batty, please raise your right hand so I can place you under oath for the limited purposes of taking the plea. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury for the limited purposes of taking the plea?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No,
Did anyone promise you anything in exchange for taking a plea?
no, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Do you understand that by taking a plea today, you'll have no other court dates regarding these charges?
Yes, ma'am.
And you're giving up your right to trial by judge or by jury?
Yes.
And you're further giving up the right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you understand the requirements. You have an anti-theft course to pay, a $500 fine. You cannot go back to either the Publix or that Walmart on Union City, but otherwise the time you served in Fulton County Jail should close your case. You understand that?
Yes, ma'am.
All right, as to the charge of theft by shoplifting, Mr. Batty, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there any, Ms. Falk, yes?
Yes, Your Honor. Okay, so I'm gonna blame Cybergeddon for this, and that's actually a valid blame. On February 29th of 2024, the defendant did enter a plea on that Publix case.
Shoplifting, so we're only here for Walmart. Okay.
Right. So what appears to have happened is when they added the case into the system, it just didn't get closed out.
Okay, so the Publix case is closed and we've addressed the Walmart case. Is
Correct.
there anything additional, Mr. McLean?
Nothing else, Your Honor. Thank you very much.
All right, best of luck to you, Mr. Batty.
All right. Thank you. You're gonna be out there. Yeah. You know.
All right, who do we have next?
Marietta Annex,
All right, who's at the Marietta Annex?
position number 34, Roland Ward. Last slide on. Third row, third row, slide.
Okay, the announcement I have is that this is a not guilty. Are we
Yes.
addressing bond today?
No, Your Honor, there's another case which makes a bond on this matter apparently not an issue. I don't know if this is holding him in, actually. We could check on that. But he was the last interview, and there was a comedy of errors where we went back and forth from the main jail building to the Marietta Annex about 2 or 3 times. He was a kitchen detail. So we finally got an interview, and he says, this case is not guilty.
Okay. All right, so Mr. Ward, your attorney is gonna enter a not guilty plea following court today. There's some more work for them to do as it pertains to this matter, so your case will be reset for trial, okay? All right, Mr. Ward, I believe that concludes this case. Is there anything else, Mr. McLean?
I'll file a written waiver. Thank you.
All
And
right.
Your Honor, Mr. Ward is being held on a $4,000 surety bond for 2 counts of theft by receiving stolen property in the felony court.
But not for this, right?
Correct.
We
Okay.
made bond on this, okay. All right, bye-bye, thank you. All right, who can we take up next?
Okay. All right. Thank you. Who do we have? Jeter, is he the top guy? Yeah. You know, I need to talk to him. Go somebody else.
We can go to Miss Watson Cafe's client if she's ready?
She's not back yet.
Or we could go to position number 26. Oh, no, that's Miss Vigilante's client.
No, 26 is mine.
Miss
Justin,
Jonathan Roseberry. That's 23.
that's 23.
Yeah.
Yeah, that's not mine. If he's there, Justin Shaw here. Justin, Rex. Come on, 26. Your Honor, it appears that we have 26 here in the courtroom. Mr. Justin Shaw, he has a failure to appear that will be non-prossed on number 27 as we do the negotiated plea for 26.
Okay. All right, good morning, Mr. Shaw. Your case is 23 CR 003376D. In this case, you are charged with criminal trespass. You also have an FTA. Do you understand your rights today? All right, and the announcement is negotiated plea. Ms. Falk, please proceed.
Yes, Your Honor. This defendant entered upon the premises of the Studio 6 Motel, which is located at 9955 Old Dogwood Road in Roswell. He had been previously ordered not to enter that property, and so that is the basis of the criminal trespass on May 28th of 2023. The state's recommendation on this case is 12 months served, 54 days, credit for time served. Excuse me, let me amend that. Serve 48 days, credit for time served 24 days. That's going to be from May 28th to May 30th and November 17th to November 28th of 2023. And then again from March 29th of 2024. We're asking the balance be suspended and that the defendant stay away from Studio 6 Motel located at 9955 Old Dogwood Road in Roswell. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea, and the amendment to 48 days with credit for time served 24 days would then release him today.
Is that your understanding of the offer, and do you so stipulate, Mr. McLean?
It is our understanding, and for the purposes of the plea, we do so stipulate.
All right, Mr. Shaw, please raise your right hand. Do you swear and affirm the testimony you give today for the very limited purposes of taking the plea to be the truth to the best of your knowledge and under the penalty of perjury? Is that a yes? All right, we're gonna need you, you can put your hand down. We're gonna need you to speak as loudly as you can because we need to make sure you're voluntarily taking the plea today. Are you under the influence of any drugs or alcohol at this time?
No,
Did anyone force you to take a plea?
no,
Did anyone promise you anything in exchange for taking a plea?
no,
And you understand by taking a plea, you're giving up your right to trial by judge or jury?
yes,
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
yes,
And you further understand the requirements that you cannot go back to that motel, but otherwise the time you serve should close your case.
yes,
And you further, and did you say that you were satisfied with Mr. McLean's representation?
I am
All right, as to the charge of criminal trespass, how do you plead?
guilty.
I accept your guilty plea. Is there anything additional, Mr. McLean or Ms. Falk?
Nothing from the defense, Your Honor.
All right. Best of luck to you, sir. That concludes your case.
Could I ask the litigation manager if she doesn't mind to send me Mrs. Akia Watson Cafe's email address so I can send her this plea paperwork? I can't seem to find it anywhere in my emails.
If you have it, please send to Ms. Falk.
Thank you.
She just came in on the Zoom, Ms. Falk.
There she is. Ms. Watson Cafe, will you please chat Ms. Falk your email address so she can send you plea paperwork?
And
Okay.
also, an update on Mr. Salter, that's going to be a plea.
Okay. All right, if we can go ahead and can we do Mr. Salter's case?
It is, there is an issue with the, I don't know if we can resolve that right now with time served, the time that he has done. I remember when I first took the case on, he had served a pretty significant amount of time on this case. So it shouldn't just be the 12 days. He believes it's about 7 months.
On this particular charge, can we check and see how much time Mr. Salter has served on this simple battery case to see if he's gonna take this plea today?
I'm checking now, Your Honor.
Okay, thank you.
Okay. Miss Watson Cafe is correct. The defendant has actually spent 213 days.
On this charge?
Yes. So obviously the state is still going to be asking for the same recommendation. However, it's going to alter, especially the FVIP, since FVIP is a 24-week program and he only has about 130, about 130 days left. So we would amend that to something like 8 weeks anger management.
Okay.
So,
So my understanding is he's already done the FVIP class. I don't know if he has or he said that he has a certificate, so he should. Can we put it in the alternative? He either, shows the certificate or completes the 8 week management, anger management.
State doesn't have any objection to that as long as it was subsequent to this case. I mean, I'm not trying to be funny,
it would have
but I
been.
just
So
want to make sure that
got out.
Okay, got it.
Okay, so we'll do the alternative, and so the time will be 12 months. 12 months probation served.
Okay, so
365, but credit for 213.
Yes, so it'd be 12 months served, 213 days, credit for time served. 213. We're gonna ask for day. So it's gonna be 8/31/2021 to March 18th, 2022, and then March 29th, 2024 until today.
Okay.
Ballots would be probated. We'll ask for FVIP unless he can show proof that he has completed FVIP, 40 hours of community service, stay away from 4030 Melanie Woods Drive, South Fulton, no further contact with Tracy Arnold, and we're requesting that there be no firearms. This incident happened back on January 30th of 2021, involved, as I stated, Miss Woods, and involved him striking her, let's see, and pushing her out of a vehicle. And that was Miss Tracy Arnold. I misspoke. My apologies. The state would ask the defense to stipulate to venue factual basis and identification for the plea, and we would like to sound for Miss Tracy Arnold.
All right.
Yes. And full disclosure, I think that I think it needs to be non-negotiated. Most of the terms were amendable too, but I'll explain. I don't want to interrupt your presentation of the case, but we
Oh,
do
no,
stipulate the
state's
factual
done.
basis. Oh, okay. We do stipulate. I guess we need to sound for her. But my understanding is that she did not have an issue, so we would be asking for no violent contact with her.
Okay, is Ms. Arnold present and wishes to make a statement? And has the state or defense had any contact or discussions with her?
Your Honor, just going back to double check, I will just point out for the record that one of the reasons the state was asking for no further contact was because the defendant had a case that was null pros 22 SC 180385, which involved theft by taking, interference with custody, and kidnapping. And that was null pros as a result of, I believe, looking at the null pros order from September 9th of 2022. Just to pull that up briefly, he completed a parenting course as a precondition for the null pros in that case. And that, I believe, did involve Miss Arnold as well, just double checking the indictment on that case. The theft by taking involved Miss Arnold, and they did not present the kidnapping, and then the interference with custody involved Miss Arnold's child that she shared with the defendant. And so that was the reason for the state's recommendation. Just going back and checking our notes from this most recent case that he has, it appears that just... Excuse me, Your Honor.
That's okay. Ms. Watson Cafe, have you spoken with her?
Notes that I spoke to her, but that was years ago.
Okay.
And we were, it looks like, unsuccessful in our last attempt to reach her. However, the last time we did speak with her, she was on October 9th of 2023. And we informed her of an upcoming court date. Prior to that, she had stated she was, that they had one child together. She was in fear, does not want any more contact with him. That was back in 2021, and then referenced the kidnapping. Subsequent to that, in September 2023, she stated everything was good. She's still talking to the defendant. However, it doesn't indicate she ever asked for a no further violent contact as opposed to a no further contact. So for that reason, we are asking for a no further contact. If she wishes to amend that condition, she can always come to the court and request it.
Okay. Ms. Watson Cafe, if we go forward with the plea, I would accept the state's recommendation that it be no contact until we hear or get a statement of some type from the alleged victim amending that contact provision. Does your client want to take the plea today?
Mr. Salter, do you want to take the plea as is? You would, is he on mute? Can we take him
Can
off
we
on mute?
unmute that courtroom too? Can we unmute Mr. Salter at courtroom 2, please?
Mr. Salter?
Yes.
Do you want to, the plea, they're gonna have a no contact order with Ms. Arnold until she informs otherwise. We would have to amend it. It would still be probation for the remaining, but you are getting credit for the 213 days.
Okay, how much probation is that?
It's just 12 months. Oh, less. I see, now you got me doing math. Can someone do 365 minus 213?
That's what I'm trying to do.
152. He'd have 152 left, which rounding out is about 5 months.
Probation. that okay?
Yes, that's fine.
Okay.
Okay. So I guess the non-negotiated part of the plea, we would ask that it either terminate, Your Honor, after he completes the terms, or it go non-reporting after he completes the terms.
Okay, he can, I'm fine with not reporting. Any objection from the state?
Yeah, we object just based on the history.
Okay, well, if he's completed things, he can go non-reporting. It won't terminate, but he can go non-reporting. Does he still wish to take the plea today? All right.
In the terms, Mr. Okay.
What is the term?
So it's 12 months probation, less than 213 days that you've completed. So that leaves 5 months. While you're on probation, you have to complete you either have to show that you completed the FVIP course, or you have to do an anger management course if you don't have the certificate for the FVIP course, completion of the FVIP course. And then you would have to also do 4 hours of community service. Once you complete those 2 things, your probation will go non-reporting.
All right, thank you.
So do you wish to take the plea?
Yes.
Oh, and I'm sorry,
All right, and Ms. Watson, you did stipulate to the 3 elements, correct?
yes.
All right. All right, I think we're ready to move forward. Mr. Salter, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand taking the plea, you're giving up your right to have the state prove these charges, well, this charge against you beyond a reasonable doubt?
Yes, ma'am.
And you further understand that you'll have no further court dates regarding this charge?
Thank you. Yes,
And you understand the requirements that the time you serve, you should not have any additional time to serve at the jail, but you will have to either take anger management or produce that FVIP certificate, complete 40 hours of community service, and have no contact with Ms. Arnold until such time that she amends that contact provision by filing something with the court. You understand that?
yes, ma'am.
All right, as to the charge of simple battery family violence, Mrs. Salter, how do you plead?
Yes.
Is there anything additional, Ms. Falk or Ms. Watson? Cafe?
Nothing from the state.
No, Mr. Salter, do you authorize me to sign the plea paperwork on your behalf?
Yes, ma'am.
And he also needs to do that probation sheet as well, where his information is given to probation. All right.
Okay.
Best of luck to you, Mr. Salter. And Ms. Watson Cafe, does that conclude your business?
Yes.
All right. Take care. You are free to go at this time.
Excuse me,
Thank you, Honor.
it's Miss Grace. Can I get the understanding if he's show proof of anger management?
No, he has to either show us he already took FVIP or
Uh-huh.
he has to enroll in the 8-week anger management class if that FVIP certificate is not subsequent to this charge.
Okay, so it will be the 8 week of anger management. I will put down on the special condition. Okay, thank you.
All right. Is there another position we can take?
We can go to position number 11, Robert Hughes.
Robert Hughes is going to need to be a reset at this time, Your Honor. It's a communication problem and we'll get a social worker started. And after that, we'll follow up if necessary with a MH referral.
How much of a reset are you asking?
1 week.
Yes.
So 1 week for a social worker to come out. Is there room on next week's calendar?
Yes, we need to do it out for the 1 week. Yes, ma'am, Miss Room.
Okay, so we will reset to next week's calendar. That should be the 16th.
Thank you, Your Honor.
We can go to position number 13, Philip Johnson.
All right, and the announcement for Mr. Johnson?
I believe that is a negotiated plea, Your Honor.
Okay. All right, Mr. Johnson, your case is 24 CR 001439G. You're charged with public drunkenness and unlawful conduct during a 911 call. Do you understand your rights today?
Yes, ma'am.
All right, Ms. Falk.
Mute button. The state's recommendation on this case is 12 months probation, serve 30 days, credit for time served 15 days. That's going to be from March 26th, 2024 to today, balance probated. Stay away from 11515 Alpharetta Highway, which is the racetrack in Alpharetta. We're also asking for alcohol drug evaluation and treatment. On count 2, the unlawful and harassing phone calls, the state is requesting 12 months probation that is to run concurrent with count 1. This incident happened back on March 26th of 2024, and the defendant called dispatch a total of 11 times complaining of a leg injury, and the officer had already made contact with the defendant once before. He went back out to that location. The defendant again denied medical treatment and started cursing out the officers and showed that he was very intoxicated, which is why he was arrested for this offense. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
For said purposes, we do so stipulate.
And that was your understanding of the offer as well?
It is.
All right. Mr. Johnson, please raise your right hand. I'm going to ask you some questions to make sure this is a voluntary plea, okay?
Yes, ma'am.
All right. Do you swear and affirm the testimony you give today be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
And are you satisfied with Mr. McLean's representation?
Yes, ma'am.
And you understand you're giving up your right to the trial by judge or jury at this time?
Yes, ma'am.
And do you understand that by taking a guilty plea, it may affect other aspects of your life that I can't or your attorney may not be able to anticipate, such as employment, immigration, or probation?
Yes, ma'am.
And you understand that you cannot go back to that racetrack. You have some evaluations to undergo, but otherwise, the time you serve should close out your case. You understand all the requirements?
Yes, ma'am.
All right, as to the charges I previously listed, Mr. Johnson, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional?
Nothing, Your Honor. I have contact information to send in, and I'm just reminding him, don't forget to go to 132 Mitchell Street as soon as practical in the next few days.
All right. Mr. Johnson, best of luck to you.
All right.
We can go to position 14 and 15.
All right, I have that this is a negotiated plea. Is that correct?
That's Mr. Jones, and that is correct.
Okay.
(14) and 15, I have Rasul Jones.
Right.
Yes.
Okay, just wanted to make sure.
All right, Mr. Jones, your case is 23 CR 003201H. You have an FTA, but you're also charged with theft by receiving with the offense date of May the 18th. Do you understand your rights?
Yes.
All right, and Ms. Folk.
Yes, Your Honor. This incident, we are recommending 12 months probation. That is going to be suspended. The balance will be suspended upon the service of, and I just want to make sure it says 3 days in custody, which would be, let me just double check that for a second. The defendant was in custody from April 1st of 2024 to April 1st of 2024 to April 9th of 2024. So he's actually served 8 days. That was on a FTA. Previous to that, he was arrested and served 3 days. So it's actually going to be 11 days. So we're going to ask for 22 days with 11 days credit for time served. The incident itself happened back in 2023 and involved this defendant taking a cell phone that was had fallen. Let's see, the individual fell asleep on the North Doraville train, stated an individual took his iPhone. And then later on, the iPhone was located on Mr. Jones' person on the Peachtree side at where he stated he had purchased it from a man at Garnet Station for $1. And so he later on said, yeah, I needed the money. I'm homeless. And so that was why he was arrested for this offense. The state has nothing further, and the phone was returned to the defendant, to the victim, excuse me. State would ask the defense to stipulate to venue factual basis and identification for the purposes of this plea.
For said purposes, we do so stipulate. Can I have just one moment on mute to explain a change in terminology to him?
Yes, and I'm gonna go to the printer very quickly to get the probation calendar while you do that. So give me.
PD McLean. There is one thing we do need to add as part of this theft by receiving, and I understand if it changes the negotiation, but it's sort of a kind of built in. So this defendant has a 365-day suspension through MARTA that doesn't expire until July 8th of 2024. So we would like to add as a condition of this plea that he stay away from all MARTA stations until July 8th of 2024. Which is concurrent with his 365-day suspension. We're not asking for it to go any further.
Understood. Let me talk to him.
Thank you.
He's okay with that.
Okay.
Okay, I heard something about a change. What's the change?
Yes. It was just very brief, Your Honor. This defendant, as part of his the incident, was given a MARTA suspension for 365 days, which expires July 8th of 2024. All that I asked was for an addition of a stay away from MARTA until July 8th of 2024.
Okay, so he's gonna
And the
comply
defense
with,
agreed to that alteration.
so he's gonna comply with any active MARTA suspension. All right.
Correct.
All right, did I already place Mr. Jones under oath? I don't think I did.
Did you raise your hand?
Please raise your right hand, Mr. Jones. And do you swear and affirm the testimony you give today for the very limited purposes of taking a plea will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. All right, are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea?
Correct.
Did anyone promise you anything in exchange for taking a plea?
No.
And you understand that by taking the plea, you're giving up your right to trial by judge or by jury?
Correct.
And you further understand that you're giving up your right to have the state prove this charge against you beyond a reasonable doubt?
Yes.
And you understand that you can't use MARTA until July the 8th of 2024? And you'll need to stay away from all the stations?
Yes.
All right. Otherwise, the time you have served should close out this matter. As to the charge of theft by receiving, Mr. Jones, how do you plead?
Yes.
I accept your guilty plea. Is there anything additional?
Nothing, Your Honor.
All right. Best of luck to you, Mr. Jones. That concludes your case.
Good luck.
Good luck. Right. What position? I'm sorry.
Quick announcement, if Oconee can call the extension I put in the chat.
Okay, at the Oconee County Jail, please give courtroom 2 a call. If anyone is there.
Right here. We are.
Do we know who's at that location?
Yes, Judge, this is Jacob Smith. Mr. Smith, is there a deputy with you?
Yes.
Okay, if that deputy, please give courtroom 2 a call.
Thank you, Judge.
PD Vigiletti, I did reach out to Miss Reddick, who's over with DUI court. She says that he would be eligible.
That was Ms. Prater.
Right. But I think that plea would need to be taken in Judge Taylor's courtroom as part of DUI court.
Right, so we'll need to tell her and then reset it for the notice.
And yeah, and I do, I know the offer on the table as it is would have gotten her out of jail today, so I will have to give her that option, I guess.
Oh, that's true. Okay, so when ACDC comes back, we'll address it that way.
Thank you, Judge.
Your Honor, may I interject for real world chat instead of the virtual chat for a second?
Yes.
Ms. Falk, I have a question. On the fellow
Yes.
from Cobb County, I wasn't able, of course, to interview him until this morning because he's in Cobb County Jail on rented space. But my question is this the only domestic violence case that's open that he has?
Can you give me a name?
It is Mr. First name is spelled D-A-J-U-W-A. Last name is Jeter, spelled J-E-T-E-R.
Number 12. Okay, Dewan Jeter. Let's see. And you're asking if this is his only case.
Right. We need to make sure that there's no other outstanding simple battery or anything like that.
Let me just check.
Since I doubt citations are involved, GCIC would probably be sufficient.
It is not his only case.
We need to go along.
So we're gonna have to reset this because he actually has 3 cases in total.
Yeah.
There's no offer anymore?
You're
It'd be good if I went forward on this alone.
Yeah, Your Honor, it just looks like the person who prepared the recommendations missed the fact that he had 3 open cases, not just 1. And so there is 375, 376, and 1424. And so normally what we do in this instance, Your Honor, is we reset 1 week so the state can do a global recommendation as to all his cases. Mr. McLean, I will just put on the record that he also has an open felony burglary, 1st degree, and family violence simple battery that is open in felony division. So I just wanted to make you aware of that as well.
I see the victim on the line was the only reason I asked if there was anything that could be done today. Because I'm
Understood.
sure the victim wants to be heard. But okay, so Miss Miosha Reese, are you present?
Yes.
Okay. The alleged defendant in this case, his matter will not be addressed today. I do see you on the line. I know you were prepared to make a statement. Unfortunately, we're going to have to reset the case to 1 week so some further development can be done. So if you want to reach out to the state's victim advocate to speak with them or to give them any additional information, or to Mr. McLean, you can do that, but we cannot take up the case today. It's going to be reset 1 week, okay?
Okay, can I have his attorney's information and the victim
Can
information?
someone chat that to Miss Reese? Mr. McLean, are you able to put anything in the chat?
Yes, I'll give her a number that she can text me at this afternoon when we're through with court.
And Miss Maldonado, if you would chat her some information too, so she can reach out to you. Okay.
Okay, thank you.
All right. You might want to wait. Don't log off, Miss Reese, until you have those contacts, and then you can go. All right. Is there another position we can take up?
If medical is ready, we can go to medical.
We got position number 4 right here, Mr. Camps. Mrs. Camps, I'm sorry.
All right. Your case number is 24 CR 001426J. You're charged with 2 counts of simple assault. Do you understand your rights?
Sure.
Is that a yes?
Yes,
All right.
yes, ma'am.
Thank you. All right. The announcement I have is that this is a plea. Is that correct?
Yeah, yes, Judge.
Okay. All right, Ms. Falk, please proceed.
Yes, Your Honor, just to make sure, which position is this?
This is for and I'm sorry if I'm saying it incorrectly, Estipendio Camps.
Yes, Your Honor.
Estipentonio.
And her
Yeah.
preferred name is Minnie Camps. So I noted that as well.
Okay, thank you.
Your Honor, the state's recommendation on this case is going to be on count 1, simple assault, 12 months served, 30 days, credit for time served, 15 days. That's going to be from March 26th of 2024 until today. We are also requesting balance suspended, stay away from 1700 Monroe Drive, northeast. That is the Kroger. We are also asking for no further contact from Timothy Nyberg and Joshua Hagedorn. That is Timothy, common spelling, and Joshua, common spelling. Last name for Timothy is Nyberg. Last name for Joshua is Haggadone. That is due to the victim's request, Mr. Joshua Timothy Nyberg, when we did speak with him. On count 2, the state's recommendation is 12 months probation concurrent with count 1. This incident happened back on March 26th of 2024. The defendant was attempting to shoplift and held up a canister of pepper spray and sprayed it in the direction of Mr. Nyberg and Mr. Hagedorn. That is all for the state. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. We would like to sound for Mr. Hagedorn and Mr. Nyberg, although Mr. Nyberg stated he would not be on Zoom today.
Okay. I'm gonna do the soundings first. Is Mr. Nyberg or Mr. Hagedorn present and wishes to make a statement? All right. Ms. Vigiletti, do you so stipulate to the 3 elements, and was that your understanding of the offer?
Yes, it was, and we do stipulate for the purposes of the plea.
All right. Will you please raise your right hand so I can place you under oath, Ms. Camps? And can we unmute? Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No.
Are you satisfied with your attorney's representation?
Yes, ma'am.
And you understand that by taking the plea, you will have no further court dates regarding this charge?
Okay.
And you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you're giving up your right to have state prove this charge against you beyond a reasonable doubt?
Yes, ma'am.
And you understand the requirements that you should not have additional time to serve at the Fulton County Jail. However, you cannot return to that Kroger on Monroe Drive, and you can have no further violent contact with either of those 2 individuals. Do you understand that?
Yes, ma'am.
As to the charges of simple assault, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything additional from state or defense?
No, ma'am. Thank you.
All right, best of luck to you. That concludes your case.
Thank you.
All right, is there another position we can take?
We can go to position 17 and 18, Millfield Brown.
All right, I have that this is a negotiated plea. Is that correct?
That is correct.
All
Yes.
right. Are you Damari Minifield Brown?
Yes.
Your case is 20 CR 002135A. You're charged with battery with the offense date of March the 22nd of 2020. Additionally, you have an FTA. Do you understand your rights today?
Yes, ma'am.
All right. Ms. Falk, we're taking up position 17.
I appreciate it, Your Honor. This is to the recommendation is 12 months served 60 days, credit for time served 23 days. That's going to be from March 28th, 2024 to today. The balance will be probated. Family Violence Intervention Program, no further contact with Kristen Mincy, that is Kristian. Stay away from 4653 Tartan Court. That's going to be in Union City, here in Fulton County. This incident happened back in 2020 of, let's see, March 22nd of 2020. And the information that we have is that on that date, let's see, my Odyssey is just acting up at the moment.
That's okay.
On that date, and this was a bind over case, Your Honor, just to let you know, on that date, the defendant stated, well, the victim, Miss Mincy, stated that she and her boyfriend had broken up. She was trying to leave, and that the defendant struck her, causing her to have bleeding from a laceration above her left eye. She also identified him as the person who punched her. The state would ask the defense to stipulate to venue, factual basis, and identification, and we would like to sound for Miss Kristen Mincy.
Do you so stipulate, and was that your understanding, Mr. McLean?
It is our understanding for the purposes of the plea, we do so stipulate this issue.
All right. Is Kristen Mincy on the line and wishes to make a statement? All right, hearing and seeing none. There is additional time to be served, correct? Under this plea agreement, is
That
it
is
3
correct.
days? Is an additional 3 days? Is that my math? I'm so bad at this. How many additional days will he have to serve?
Let's see, number 17, let me go to my code section here.
Does I have? Oh, no, it's not 3 days. So I have.
It's from, he gets credit from the 28th day of March. So that would be March would end up with 28, 29, 30, 31. 4 days of March, we've got 9 days of April. So 4 plus 9 is 13. There's some other, I know there's something else though.
I never know how to do this.
I remember looking at this yesterday and there
Ms.
was,
Lewis, can you help me? How many additional days does he have to serve?
Is it 60 after service of 60 to 23, Ms. Falk, or did you
Or
change?
Ms. Graves?
It is 60 to serve with credit for time served for 23 days.
So shouldn't it be 7 more if it's gonna be 30?
right,
That's what I think so.
we had 10 days from somewhere, I know, but
I want to make clear that he knows. I think it's 7. That's the math I had, because it would have been 14 if you do it the other way, credit for the 2.
right.
Okay.
Just a moment, I'm mute for a second. I need to ask him about a previous jail. There we go.
Thank you, Ms. Grace.
No problem. Hopefully we're right.
Please don't ask me to do math ever.
Oh. Ms. Falk, can you look at your chat for me, please?
I can indeed.
Thank you.
Okay, we've straightened out our thoughts about another jail that didn't have anything to do with this. So we are clear on 7 days. He'll be released on probation. I've got his contact information. He needs to go to 132 Mitchell ASAP 7 days from now.
Okay,
All right.
so that's 60 to 23, correct, Judge?
Yes.
Okay, thank you.
All right. Mr. Minifield Brown, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury? All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time? Are you satisfied with your attorney's representation? Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you further understand that you're not going to have any further court dates regarding this charge, and you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you understand the requirements that in addition to the 7 days you'll have to serve, you can't have any contact with Ms. Mincy. You'll need to stay away from that address in Union City. And you'll also need to take a family violence intervention program course, which is about a 24-week course. Do you understand all of that?
Yes, ma'am.
All right. As to the charge of battery, how do you plead?
Yes.
I accept your guilty plea. Is there anything additional, Mr. McLean or Ms. Falk?
No, Your Honor.
All right. Make sure that he gives his contact information to probation. All right. Best of luck to you. That concludes your case.
All right, come on. All right. Let's go talk to them. All right, next order, we're gonna go to position number 19, Mr. Morgan.
All right, Mr. Morgan, good morning. Your case is 24 CR 001585C. In this case, you're charged with terroristic threats and acts with the offense date of February the 17th of 2024. Do you understand your rights today? All right, the announcement I have again is negotiated plea. Is that still correct, Mr. McLean?
I believe it is correct.
All right, Ms. Falk, we're taking position 19, Mr. Morgan. You're muted.
It's always something. The recommendation is 12 months serve, 108 days, credit for time served for 54 days. That's going to be from January 20th to January 22nd of 2024 and February 17th of 2024 to today. Balance probated, no further contact with Jaquan Moore, that is Juiquon. Stay away from the Dollar Tree at 2630 Martin Luther King Jr. Boulevard. 12 weeks of anger management and alcohol drug evaluation and treatment. The state did reach out to Mr. Moore. He stated he will not be on Zoom today, but does agree with this plea offer. The incident happened February 17th of 2024. The defendant was at that location, was verbally abusive toward other customers and appeared to be drunk. He was also threatening to sexually assault other customers, and Mr. Morgan then approached Mr. Moore and stated, "I'm going to kill you when I catch you in these streets." And so that was the basis of this recommendation. The state would like to sound for Mr. Jaquan Moore out of an abundance of caution, and we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
For said purposes, we do so stipulate.
And that was your understanding of the offer?
Yes, Your Honor, it is.
All right, I'm sounding for Mr. Moore at this time to see if he wishes to make a statement. Mr. Moore, if you're present and wish to, please turn on your camera. All right, hearing and seeing none. Mr. Morgan, please raise your right hand so I can ask some questions and make sure you're taking a voluntary plea this morning. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything? Oh, you can put your hand down. Thank you. Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking the plea?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
And you understand the requirements that you cannot have any contact with Mr. Moore, and you'll need to stay away from that Dollar Tree. You're also going to undergo some evaluations and treatment if necessary, and you're going to enroll for anger management for 12 weeks. Do you understand all of that? All right, and you should not have any additional time to serve at the Fulton County Jail as it pertains to this charge. Do you also understand that taking a guilty plea may affect other aspects of your life, such as probation, immigration, employment, other things that I may not be able to anticipate? All right, as to the charges of terroristic threats and acts, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional?
Nothing else, Your Honor. Thank you.
All right. Best of luck to you, sir. That concludes your case at this time. Do not go back to that store, okay?
Understand.
Understood. All right. Take care. Have a good day. All right. Is there another position we can take?
Gonna be position 20 and 21, Mr. Richard Moses. You gotta start giving them that so I can get the seat clear. Now, see, even though that be still on. All right, you're giving me a mailing then? All right, take off. But I need an emergency contact. Who's that gonna be? Who? Who would it be? No, the next one goes. Well, he's not going nowhere. All right, keep him. 20 and 21, y'all.
All right, Mr.
Who we got?
Moses. Your case is 23 CR 003728Y. You're charged with discharge of a firearm on the property of another, reckless conduct, public drunkenness, and that was with the offense date of June the 21st of 2020. You also have an FTA. Do you understand your rights today?
I understand my rights.
Thank you. Okay. My announcement that I have is that this is a negotiated plea. Is that correct?
Your Honor, that's what I've got.
Ms. Falk, is it still negotiated plea, position 20?
The state has no information to the contrary.
Okay, wonderful. All right, please proceed.
Yes, Your Honor. This case happened on June 21st of 2020. State's recommendation on count 1 is 12 months to serve 180 days, credit for time served 18 days. That's going to be from June 21st to June 23rd of 2020 and March 26th of 2024 until today. Balance probated. We are requesting that the defendant enroll in a firearms safety course. No further contact with Henry Bryant. Stay away from the Ramada Inn at 5010 Old National Highway, as well as the Cozumel Restaurant at 2471 Old National Highway Parkway. No firearms. On count 2, the state's recommendation on the reckless conduct is 12 months probation, concurrent with count 1. 40 hours of community service is an additional requirement. And on count 3, 12 months concurrent with count 1, as well as alcohol, drug evaluation and treatment is an additional recommendation. This incident happened back in, as I said, June 21st of 2020. The defendant was seen carrying a dark colored handgun and a dark rifle while walking in a parking lot. The security officer observed him, noticed the defendant point the handgun that he was toting at an unknown male while speaking loudly and then discharging a single round into the air. The defendant also went to the Cozumel and stated he wanted to flip that S. He was intoxicated, had vulgar language, bloodshot eyes, and an unbalanced state. A single spent round was located and was placed into evidence. The state's recommendation is based on the fact that he was firing a gun in a area where people were, and we are asking the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. We would also like to sound for Henry Bryant.
I'm so sorry. I am quickly flipping with my fingers through the announcement list. I may have made an error on this. This might be a not guilty today. Is it not guilty or guilty today? Not guilty. I'm so sorry. Yes, this is a not guilty. I'll file a waiver of arraignment. We can get him a copy of the accusation, and he wishes to go to trial.
He wishes to go to trial. Okay. The allegations as it stands, Ms. Falk, is that he ran from one location to the next. I was just trying to understand the two stayaways.
So it looks like he was at, yes, 2 different locations. One was 5010 Old National Highway, which was the Ramada. And then he went from that location to, it appears, to the Cozumel at 5058 Old National Highway, where a fight then started. And so he went from one location to the other. Yes, that is our statement.
Okay, completely understood. Now, the other question I have is, are we holding a bond hearing then, Mr. McLean?
Well, Your Honor, yes. Yes, we would ask for a bond reduction if that is germane. Let me see what his bond is here.
All right. In the meantime, can I have the history is
We have
Ms. Tyson?
6,500 and something else.
It is 6,500.
6,500. Ms. Tyson, can I have his history, please?
Yes. 9 arrest cycles, being in 2007, no felony convictions. He does have a misdemeanor simple battery from 2012, 1 violation of probation from 2014. His last arrest was July 28th of 2023 in Atlanta by MARTA Police Department. And that was for misdemeanor willful obstruction, theft by receiving stolen property, and receipt, possession, or transport of firearm by convicted felon or felony first offender. That case was dismissed July 2023 also, and he has 1 FTA, the one that's currently holding him in custody right now. Nothing to add, Your Honor.
And Your Honor, kind of 2 questions. It sounds like the defendant had some kind of something to be arrested for felony first offender possession of a firearm. But I will point out the defendant had a failure to appear at plea and arraignment on this case on October 19th of 2023. The Rule Nisi was ordered October 24th of 2023. There was a bond forfeiture on February 21st of 2024, and that's how it ended up on this calendar. This case was before Judge Morrow on April 2nd of 2024 for a SAP. It was reset to today. I will say that normally Judge Morrow's practice is to place the case back in front of the court where it originated from so that it can be addressed, in this case, by Judge Eady.
Okay.
Right, and his comment on the failure to appear in October the 19th was inadvertent, he told me. It is not intentional. He was not trying to skip court. And so it is good to hear that he only has 1 FTA in his record. Other than the discharge first offender, it is also good to hear that he has no felons.
Okay, so we will, we will reset him, of course, but you did ask me to consider a bond reduction?
Yes, Your Honor, at $6,500 currently, it would be good to see that at the range of 1,000 or 1,500.
How is it set now? I'm sorry, we need to let Ms. Falk give her position as it pertains to bond, but how is the bond currently set? It's 6,500 total. How is it broken down?
I had 3.
If Your Honor,
Go ahead.
if Your Honor will give me a moment, I can look at and see
Of
what
course.
it says under
And
the
I'm assuming you want it to
billing
remain.
history.
I'm
I
assuming
do,
you want it
Your
to
Honor.
remain.
That also has to do with the fact that defendant has a judicial hold that I was just actually looking at before I had to switch over. So let me address the current bond as it's set first, and then I'll address the reasons. Okay, so it looks like they just gave him a bond on the discharge of firearms, according to this bench warrant. I can send that over to the court. It is on the 23 CR case, and it says the defendant failed to appear for the underlying offense of discharge of firearms. Obviously, there are more counts than that, but that is the only count that is referred to in this bench warrant that I'll send over. And I'll send that to yourself and to the court and to PD McLean.
Okay.
So you can both view it. The state's concern mainly stems from, as I said, let me just hit send on this, from the fact that the defendant also has a judicial hold that I was just going in to look at, and that's on a 22 SC 180995 case for theft by shoplifting, 2 counts. It appears the defendant failed to appear on that case. Let me just see, and received that order of judicial hold on March 24th of 2022. It says the defendant was unavailable for prosecution, and so they placed that in judicial hold status. So there is another offense for which the defendant is currently on a judicial hold. And so the state does have concerns, not only in regards to his failure to appear for this case, but his failure to appear on that other case as well.
Oh, and also, what was the probable cause for the March 26th arrest?
The probable cause for the March 26th arrest?
You mean the October arrest?
Yeah, I'm not sure which one you're referring to, PD McLean.
We believe there was a March 26th arrest. That would be about 2 weeks ago.
The reason y'all found out I had a warrant.
Right, that was for the bench warrant on this case
Oh,
that we're
well-
here on today.
Just asking how did it come up? And I'm going to find a police report on it, but if you know, I'll find a police
Oh,
report.
I don't know. I don't know that
Well,
I have.
I just went over the facts of the case if you're asking about the incident for which he's here today. I went
No,
over
no.
the facts when I was.
He's asking like, was there a traffic stop or something that got him on the 26th where they
Oh.
realized that there was a bench warrant out?
He detained or arrested?
Yeah, I have no clue what that was.
I have
based
no
on.
idea.
I'm just showing he was arrested on the bench warrant.
I'll look it up and provide that to him.
Okay.
Okay.
So I'm sorry, I still need that breakdown for what his current bond is. I know, you may have given it to me, Ms. Falk.
Again, Your Honor, I sent you the information on the bond. There is no breakdown. It just says
Okay.
6,500 and then just says discharge of a weapon.
So
It
he
doesn't
never-
give a breakdown of the numbers and what's
Yeah.
applying to what.
Gotcha, it did, and I understand that. All right, I wanted to make sure I didn't miss it because I put a big X and sometimes my brain does not fill in the blanks. Okay, Mr. McLean, would you like to give me your bond recommendation? I'm gonna assume that it was the majority of it was on the discharge of the firearm. I think
Right.
that's a safe assumption.
It has to do
Uh,
with the date of the alleged offense is pretty far back there. The failure to appear allegation from October of 2023 is one where that's 6 months ago. And so it's not like the majority of the last several years has been because of a failure on his part. He does say the failure, which is more recent, is inadvertent.
Okay,
He'll certainly try to provide the clerk with a accurate mailing address.
okay.
So we were thinking that something in the nature of $1,000 to $1,500 surety bond would be manageable.
All right, I will reduce it slightly, but we're not gonna reduce it quite to that requested level, Mr. McLean. Give me one moment. I'm so bad at math. Okay, defendant is gonna receive a $4,000 surety bond broken down as follows. 2,500 for the discharge of the firearm, 1,000 for that reckless conduct, and 500 for that public drunk charge. He is to stay away from both of those locations, the Ramada Inn, as well as that Cozumel restaurant. Additionally, he's to surrender any firearms that he has, including the subject firearm, even though it's been quite some time. He's to have no alcohol, no drugs, and additionally, no weapons, as just specified. Is there anything additional?
I can't
Your
think
Honor,
of it.
can you give me that breakdown again? You said 2,000 for the discharge.
2,500 for the discharge.
Oh, 2,500. Thank you.
1,000 for the reckless, 500 for the public drunkenness, and if my math is correct, that should get us to 4,000.
Yep.
Mr. McLean, something you would like to add?
No, Your Honor, we're clear on the breakdown.
Okay. And please make sure you keep a current address, Mr. Moses.
And we're also asking for the no further contact with Henry Bryan. I may have just.
Oh,
missed it.
yes, yes, no contact. And let me sound again, Mr. Bryant, if you're present and wish to make a statement, this is your opportunity. Hearing and seeing none. We will reset this case to Judge Edie. And it'll be reset for the notice sent to division judge, and the bond was modified.
I'll prepare an order. Thank you.
All right. Best of luck to you, Mr. Moses. Take care.
I don't understand what's going on.
Can we mute and let him speak to Mr. McLean if he is confused?
We can go to position number 23. Jonathan Roseberry. Or did you want to do a sign? One. We could go to Oconee, Your Honor.
I'm sorry, we can go where?
Oconee.
Judge, this is Jacob Smith at Oconee County Jail.
Okay, you spoken with Mr. Smith?
I did, yes.
All
Mr.
right, and the announcement for Mr. Smith will be
He would like to enter a plea of not guilty today.
for all the,
Yes, Judge.
he has position 28, 29, 30. Let me still sound them out. And he is Shavis Smith?
No, this is Jacob Smith. I'm
Oh,
sorry.
30. Oh, so he does not have all those cases. He's
Yes, I just had a moment of panic, like, wait, we've spoken about 2 cases.
No. Okay. He is Jacob Smith, position 32 and 33.
Yeah.
Mr. Smith, you're here for 23 CR 00765 You're charged with reckless driving, fleeing and attempting to elude, driving with a suspended license, obstruction, failure to obey a stop sign back on the date of August 17th of 2023. Then you have 23 CR 00765 in which you were charged with battery and willful obstruction on November the 30th of 2023. As you are aware, you have a right to remain silent and you have a right to an attorney today. Ms. Falk, I am assuming that PG Vigilante is rejecting the offers. Will you go ahead and put them onto the record at this time?
Just unmute myself. Okay, the offers as they stand on these 2 cases on 23 CR 007651, which is the failure to obey, willful obstruction, driving while license suspended, and driving while fleeing and attempting to elude, as well as reckless driving. The total was 12 months, served 6 days, credit for time served 3 days, balance probated. There would have been a total of $1,300 in fines and 40 hours of community service. On position 33, which is the battery and willful obstruction, there would be 12 months to run consecutive with the first case, 8 weeks of anger management, 40 hours of community service, and no further contact with Myra Wilson. And we were also asking for 30 days to serve on that battery, credit for time served 3 days. So it would have been a total of 24 months, served 30 days, credit for time served 3 days, balance probated, 8 weeks anger management, 80 hours of community service, no further contact with Myra Wilson, and the $1,600 in fines. And so that was the state's recommendation, which is now revoked.
And you are rejecting that offer, Ms. Vigilante?
Yes, Judge. Mr. Smith would like to be placed on the trial calendar.
All right, so reset to a jail jury calendar. I wish there was something further we could do. Do you wish to be heard on bond today?
So Mr. Smith is actually bonded out on both cases. It's a felony probation violation that's holding him, so.
Okay, understood. All right, Mr. Smith, that's going to conclude your case. Your attorney has some additional work to do regarding these matters. So best of luck to you. Your case is now concluded for these purposes today. All right. Can we take another position?
Position number 23, Jonathan Roseberry.
What's your question?
Okay, Mr. Roseberry, your case is 23 CR 006998E. You're charged with battery in a public transit station or vehicle with the offense date of September the 23rd. Do you understand your rights? All right. The announcement I have is negotiated plea. Is that correct?
Yes, ma'am.
All right. Ms. Falk?
Yes, Your Honor. The state's recommendation on this case is 12 months, serve 60 days, credit for time served from November 10th to November 12th of 2023. The balance would be probated. We are also requesting for anger management in the amount of 12 weeks, 40 hours of community service, no further contact with Mr. Jason Jones, and stay away from all MARTA stations. This incident happened back on September 23rd of 2023. And on that date, the defendant was in the MARTA station located at let's see, 1400 Lee Street Southwest, which is going to be the 5 Points MARTA station. Officers were approached by a black male, Mr. Jason Jones, who advised that he was attacked and knocked to the ground and punched repeatedly by an unidentified black male wearing ripped jeans and a green jacket because he refused to move and give up his seat. He stated that the male then exited at the west end of MARTA station. Mr. Jones suffered a laceration to the left cheek. It looks like video was then obtained that showed the defendant striking the victim, and officers were able to place a bolo out and locate this defendant through the bolo. The state's recommendation, we did not have a chance to speak to Mr. Jason Jones, so we would like to sound for him, but the state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
We do for the purposes of the plea, but Ms. Fox, could I ask, could you repeat the credit for time served?
I have 3 days, but let me go back and look at the jailing information.
And as we do that, let's go ahead and sound for Mr. Jones. Mr. Jones, are you present and wish to make a statement? All right, Mr. Jones, I'm going to assume it's not present. Was your understanding, Ms. Vigilante, that this was supposed to be a time served?
No, Judge, Mr. Roseberry was before the court this past Thursday and was given credit for 12 days. So my understanding that since this is 5 days later that, you know, we'd be giving credit for 17 days today.
Okay, let's confirm.
Just looking at this, I think the discrepancy here is he was on he's currently in custody on a probation violation. And that probation violation does not, unless I'm wrong, is that probation violation based on a case here?
Yes, I believe that's a felony probation violation.
Okay, so we can't give him credit for time. It's 19 SC case. I can't give him credit for time served for the time he's sitting on a probation violation. And it looks like he was only in jail on this battery for 3 days, from November 10th of 2023 to November 12th of 2023. So legally, I can't give him any more credit for time served than the 3 days. So it looks like there just may have been a discrepancy when the person worked it up, where they were giving him credit for time served for a felony probation violation for which he's not entitled to time served on this case.
So how many additional days would that be? I'm doing the math myself.
So the difference between kind of our belief based on last week and what is factual based on what Ms. Fox said would be 14 days. With double credit in the jail, it would be 7 real days.
And this take that plea. Go ahead, sorry, Ms. Fox.
No.
Okay, so just I completely understand what happened, Ms. Fox. What you're saying makes sense. Mr. Roseberry did ask for more time to consider this plea last Thursday with the idea of the 12 days credit in mind. That's what he was offered on Thursday. So I'm wondering, Ms. Fox and Judge, would you consider, you know, adjusting the time served, you know, so as not to prejudice him had he taken the offer last Thursday? So it would be, I guess, my request is to adjust the time we're requesting down to 46 days so we're not adding additional time because Mr. Roseberry, you know, wanted some time to consider the plea last Thursday.
Ms. Tyson, can I have his history? Because I'm just going to consider it as a pure non-negotiated then, not in light of that. Not in light of that.
Is Roseberry correct?
Yes.
Okay. He has 10 arrest cycles beginning in 2002. Last arrest is and looks like it was in Atlanta, December 14th of 2022. And that was for criminal trespass counts of criminal trespass, no dispositions listed on the GCIC for that case. He does have misdemeanor conviction in Fulton County for battery family violence. First offense, disposition date on that case is May of 2016. He has a felony conviction out of Fulton County for hijacking a motor vehicle and armed robbery. Disposition date on that case is outside the 10-year period. It's from 2004. And he does have a failure to appear outside the 10-year period from, looks like from 2002.
Your Honor, he's also currently on probation on 19 SC 170-988 for possession of a firearm by a convicted felon. That is actually the reason he's currently in jail on that probation warrant from that outstanding case. So he actually has two felonies, that armed robbery and hijacking a motor vehicle in 2004, and then this 2019 SC case. He also has, it looks like, a criminal trespass case that was dismissed in September of 2023. And so that's what the state has looking at his record in the clerk's record as well. And then that 2015, I don't know if it was put on the record, 2015 family violence battery case where he pled out in 2016. And in this case, he's alleged to have attacked a stranger on MARTA. And so for that reason, the state isn't willing to modify the recommendation. I will say that on this recommendation, the state did put the 60 days credit for time served, 3 days on the recommendation for today's calendar. So I do apologize for the misunderstanding, but that was our recommendation that I put on the final calendar for today.
And last week's calendar definitely said 12 days.
It did, Your Honor. I don't dispute that, but we did modify that once we were aware of the error and communicated that.
Didn't actually serve the
yes,
12.
correct.
Right. And technically, I would have to change the sentence, not the credit.
And the state's sentence, we believe, was warranted based on his history.
Okay, if he does take the plea today, Ms. Vigiletti, I do understand that there was a discrepancy, but I would be accepting the state's recommendation. And he would only receive the credit for the 3 days and would have to serve 60. Would he like to still take the plea today, or would we be resetting for jail jury calendar?
Okay, Judge, we'll just, if we could speak for just one moment.
Yes.
Judge, Mr. Rosenberry would like to proceed with the plea as negotiated.
All right. All right, Mr. Rosenberry, I'm gonna ask you some questions to make sure this plea is voluntary. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury? All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No,
Do you sufficiently understand this proceeding today and feel comfortable to go forward and take a plea?
yes, ma'am.
Are you satisfied with your attorney's representation?
Ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand that by taking a plea, it may affect other aspects of your life, such as probation, employment, or immigration?
Yeah, ma'am.
And you understand you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you further understand that the requirements that you're going to have to do community service, have no contact with Mr. Jones, and complete an anger management course upon your release from the Fulton County Jail?
Ma'am.
And you do understand you have additional time to serve?
Ma'am.
All right. As to the charge of battery in a public transit station, how do you plead?
Plead guilty.
I accept your guilty plea. Is there anything additional from the state or the defense?
Nothing from the,
Mr. Roseberry is asking about his probation, given that he's gonna be in custody, for an undetermined amount of time on the felony probation violation. Is it correct, Judge, that it will start 72 hours after he's released from his felony hold?
That is my understanding as to how it works.
Okay, thank you, Judge.
All right, best of luck to you, sir. That concludes this matter at this time.
You have a left one.
You too, take care. All right, we haven't done any cases on the probation calendar. Are we gonna conduct that calendar today?
Yes.
Okay, I'm just making sure. All right, who do we have next?
We could go to HC, because you have.
All right, back to, do you need to speak with Miss Ware, Miss Vigilante?
I
See
think we
what-
can tell her, we can give her the update on the record and she can let us know how she'd like to proceed.
Okay, is it, if there's no other work we can do, I guess so, go ahead.
You have position 7.
If we could do another position and Miss Vigilante call, that might be faster. But if we can't,
We can go to. Wait, are you guys doing an option for? HCC?
I did Travis Williams.
can we do a case though with Mr. McLean has, and Miss Vigilante, I'm gonna ask you to just give her a call so we can keep going.
Sure.
Okay.
Sure,
So
that's
we
no
can
problem.
go to position 28 through 30.
Deputy Milton, could you give us a call in courtroom 2?
Travis Smith.
Okay. And what is the announcement for Mr. Smith?
Your Honor, he needed to clarify, he's got 3 separate cases. It's global offer. He has East Point jail time, which I pointed out to him when I came to him yesterday. I said, I need to get certified copies ideally, but during court, it is possible that if the Odyssey shows that you came from the East Point jail, then people may well believe that you are credible when you say how many days you spent in the East Point jail on the bind over of 2 of these 3 cases. So on 2 of these 3 cases, he believes he has substantial number of days. I'm talking in the neighborhood of something like 5 to 10 days, 10 to 15 days extra beyond what's showing here. I think what's showing here is what, 8, something like that?
I don't have, let's see, are we talking about which case as it pertains to the shoplifting?
Everything but the most recent. Now, the most recent, by definition, he has the number of days of jail credit from the time of his arrest on the spot. But on the cases which are a little older, he was arrested. The College Park police took him directly to East Point Jail, which they use because currently they don't have a jail cell of their own and they have a cooperation agreement. And then he would have come from the East Point Jail on a bind over to us. And so those are the cases that would be, if I could prove that, it's going to take me time, or we could just listen to him and say whether that sounds right.
Are we able to see at all if he had any time at the East Point jail, or is that something we wouldn't be able to see?
He's saying we can call, but I've tried to explain to him, just people
Okay,
calling.
no, we
on
can't
phone.
call. That's not how that works.
is
Not
this
how
Mr.
that-
Chavez?
This is Mrs. Smith, position 29, 28, 29, and 30.
Yeah, I thought so. Let me just double check. I'm looking at the bind over right now. It looks like he was sent over on the disorderly conduct on April 2nd. I'm looking at the police report, which I can send over to Mr. Plain. On the simple assault, Mr. Smith was cited and released on a copy of charges for disorderly conduct. So that was that case.
Wait,
On
hold
the
on.
next-
I don't, so hold on, Ms. Paul. I don't even have a simple assault. I've got a disorderly.
Right, it was it was changed to disorderly conduct. It looks like
Okay.
he was cited for disorderly conduct instead.
Okay.
On the other case, it does look like he was relinquished to jail staff on this October 9th, 2020 case.
Is that
But
the
I'm not sure what the release date on that was.
Is that the La Quinta or the Walgreens?
That's the La Quinta. The Walgreens, it looks like he was transported to East Point Jail and then released. But again, that's the Walgreens case. Sorry, is it Walgreens correct? Yeah, that's the Walgreens case. And I'm trying to find out the date of release because I'm not seeing any bonds on any of these. So I'm not sure how long he served back on those other two cases before he was released. I can send you, Mr. McLean, I can send you the bind over packet and you can see if you can see anything. So I'll forward you over the bind over packet. It contains all of his cases.
Okay, as soon as I get my device over to the window where the reception is better, I will do that.
Okay.
That may come through on the laptop as well.
I just sent, so it should just take a moment.
Okay. So if we could hold on Mr. Chavez Smith, we have Travis, is it Williams? Travis Williams is a non-negotiated plea and that's ready at this time.
What about Eric?
Eric Smith is a plea and that's, I believe that's a negotiated plea, is it not?
So,
That's ready at this time as well.
31, we can go to position number 31, Eric Smith.
Okay.
Okay, Eric Smith.
All right, Mr. Smith, your case is 24 CR 001437E. You're charged with 2 counts of criminal trespass and 1 count of a charge I will not sound. Do you understand your rights today?
Yes, ma'am.
And this is a negotiated plea?
It is.
All right, Ms. Folk.
And just to make sure I'm on the right one, this is Eric Smith.
Correct. Position 31.
The state's recommendation is 12 months served, 28 days. That would be credit for time served for 14 days. That's going to be from, let's see, March 26th of 2024 until today. The state is also recommending a stay away from the location of 216 Peachtree Street in Atlanta, as well as 40 hours of community service. Count 2 would then merge with count 1 because they are based on the same factual pattern. And then count 3 would be 12 months probation. That's going to run concurrent with count 1. This incident happened, and the stay away is from the MARTA. This incident happened at Peachtree Center MARTA station. The defendant went wayside onto the trackway without permission. He stated to retrieve a cell phone. He also has a permanent ban from MARTA per a suspension check that was issued on September 18th of 2023. So he's actually not permitted to be at any MARTA station, and he did urinate on the platform. And so that's all for the state. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
For said purposes, we do so stipulate, and that is expected, right. That is what we expected to hear today.
All right, that is your understanding of the offer. Mrs. Smith, please raise your right hand so I can make sure the plea is voluntary. Do you swear and affirm the testimony you give today for the limited purposes of taking the plea will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Are you sure? You were not forced, it has to be voluntary.
No, ma'am.
Do you wish to take a plea today?
No, ma'am.
You don't want to take a plea?
No.
Would you rather take it to
Okay.
trial?
So if he doesn't want to take this plea, we're gonna have to reset him for trial.
No, I'll take a plea.
Are you, this has to be voluntary. We can't force you. No one, you have to want to take a plea. Would you like to speak with your attorney? Are you 100% sure?
I can talk to him, Your Honor. I think any doubts he has, I think has to do with our terminology and our.
Okay, please
label.
speak with him very quickly, because if not, we'll have to reset this case.
Okay. Let's go in the back with Tom. Okay. There's the back.
All right, so we're holding on, I've already forgotten, position 31. All right, is there any other matters we can take up while we hold?
Miss Grace, just to ask you a real quick question, do you have all of the null pros orders? I forwarded you, I think, 3 from the cases that entered pleas. I just want to make sure I have sent you all of the ones where we are agreeing to null pros.
I am so sorry. I am sitting at Miss Lewis's desk and I can't pull
Not a
up.
problem at all.
Yeah.
Don't worry about it. Just do me a
Thank you.
favor when you get the null process. If you're missing any, just let me know.
Will do.
Thank you.
Mhm.
All right, we'll be on a very brief hold. All right, does Mrs. Smith wish to take the plea? We're muted at courtroom 2.
There we go. I explained to him the terminology of the word plea, and I think that straightened things out.
Okay, so Mrs. Smith, you're still under oath. Do you want to take a plea today?
Yes, ma'am, I would like to take a plea.
You're 100% sure you wish to do so?
Yeah, I'm 100% sure. Yes, ma'am. Yes, ma'am, I would like to take a plea.
All right, and you're satisfied with Mr. McLean's representation?
Yes, ma'am, I am.
And you understand that you absolutely cannot go back to MARTA and you have 40 hours of community service to complete?
Yes, ma'am, I do. I'm listening.
And you understand that you're not gonna have another trial. You're giving up your right to make the state prove this charge against you. You understand that?
Yes, ma'am.
And you further understand that this taking a guilty plea may affect other aspects of your life, like when you try to get a job, or if you end up on probation for something else, or other things that your attorney or I may not be able to think of. You understand that?
Yes, ma'am.
Okay, Mrs. Smith, as to the charges against you that I listed earlier, how do you plead?
I plead guilty.
All right, I accept your guilty plea. Is there anything additional from state or defense?
No, Your Honor.
All right. Best of luck to you, Mr. Smith. That concludes your case.
Good to meet you.
All right. Thank you.
All right.
And do we have an announcement for Miss Ware yet? Is Miss Vigiletti back?
Here. Oh, yeah.
You don't want to do Travis?
Oh, yeah, I'm ready in front.
Well, that's that is the next one.
Yes, Judge, I've spoken with Ms. Ware and she has done such a great job lining things up for herself, including work, and she's on the wait list for some sober living communities. So she doesn't want to, reset this case and, take a plea in front of another judge. Getting out of jail today is very important. So thank you, everybody, for looking into that with me, but we would like to proceed with a plea today.
Okay. All right, understood. Let's go forward. Ms. Ware, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
I do.
All right, you can put your hand down. And you did hear your rights earlier, but you are aware that you have a right to remain silent. You have a right to an attorney?
Yes.
All right. All right. Ms. Falk, we're going to go back to position 35. Joanne Ware, if you would give us your recommendation as well as the brief facts of the case.
Yes, Your Honor. The state's recommendation is 12 months probation, serve 44 days in jail, credit for time served 22 days. That's going to be from March 19th of 2024, $2,500 fine, 240 hours of community service, DUI risk reduction within 30 days of release. That is per the statute, as well as victim impact panel and ADET. The state is also recommending that the defendant engage in absolutely no driving. So that is also statutory, being that this is her third offense within the last 10 years and her fourth offense in a lifetime. So I do want to make it clear to Ms. Ware that should she have another offense, this would, any subsequent offenses after this for DUI where she is charged would then be a felony offense, because that would be her fourth in 10. This incident happened back on October 21st of 2023. The defendant was in the parking lot with her vehicle disabled. And when officers did make contact with her, there was an odor of alcohol emitting not only from her, but also from her vehicle. That was at 700 Holcomb Bridge Road in Roswell, Georgia. That's all for the state.
All right, Ms. Vigiletti. Well, do you stipulate to the three elements? And was that your understanding of the offer?
Yes, Judge, we do for the purposes of the plea, and that was our understanding of the offer. If I may, Judge, I did have one request this morning. I understand the terms of the offer are almost entirely statutory, if not entirely statutory. If I may just turn your attention to OCGA 46391G, that's a statute that does allow Your Honor to suspend up to half of the fines associated with a DUI if a client is going to treatment. Ms. Ware did voluntarily check herself into Ridgeview, which is a rehab facility after this incident. I have rarely seen a person in this courtroom who wants to be sober as much as Ms. Ware wants to be sober. She does have a sponsor. She's been going to AA. She's on the wait list for 4 different sober living communities, and it's just I really does not want to see an incident like this again. So I was wondering, Judge, if she can provide proof of either the time she spent at Ridgeview or acceptance into one of these sober living communities, if you would be willing to use your ability to waive half of those fees.
Okay. So I was trying to read the statute and listen to you.
Understood. Understood.
That didn't go quite as well as I had hoped. So you're asking me to suspend which portions as I reread?
So I believe the total fine is $2,500, and I believe the statute says up to half of the fines. And I've been saying the word fee, I meant fine. I believe up to half of the fines can be suspended, provided the defendant seeks treatment. And so, Ms. Ware could potentially provide proof of voluntarily checking herself into Ridgeview, or once she gets into one of these sober living facilities that she's on the wait list for, she could also potentially provide that information.
The better way, Ms. Vigiletti, and I don't mean to talk out of both ways, but in DUI court, we could make sure that all those things were actually taking place. I would feel better if we're not gonna go with the pure statutory requirements. I'd rather her go through DUI court, whereby some of those provisions could be checked a little more thoroughly than what I'm doing here today. If we take the plea today and we ask the questions, I am gonna stick with the statutory, or would she rather, when is DUI court? Do we know how long she would have to wait?
That's the issue. I have no idea how long. she-
Okay. Because I mean, I would feel more comfortable suspending the statutory requirements in the context of doing that within DUI court. Ms. Falk, did you have a thought?
So two things. One, I can find out when she could be evaluated for DUI court. Two, this is not something the state negotiated. So I understand the request, but this essentially makes this a non-negotiated plea from the state's perspective. Once we start asking, hey, change the fine to this, modify this, for me, it's non-negotiated and it's a jump ball at that point. So the state can recommend whatever we want.
I understand the fucking, it wasn't my intention this morning. I was really hoping to get her into DUI court. This is
Totally understand. I just wanted to be clear on the state's position. I didn't want there to be any misunderstanding about what that means as far as I'm concerned for the state.
understood. All right.
Okay.
Ms. Ware,
I'm trying to read at the same time. I understand both provisions, and it does seem that she would benefit from the DUI court. So maybe let's ask Ms. Falk, because then she would be entitled probably to all of the things you're asking for, Ms. Vigilante, which may work out better for her in the long run. Ms. Falk, let's see, will it take us more than a few minutes to find out how long she would be reset? Because if it's tomorrow, or isn't DUI court typically held every other week?
Right. And normally the issue is the attorney who handles DUI court is currently in court. And so I'm kind of trying to text her while she's also handling her
Doing
court
something
matters.
else.
So unfortunately, the delay, there's a bit of a lag because she is addressing court matters for trial. So
Okay.
I can't
Ms.
really hold
Vigilante,
us down to that.
Ms. Vigilante, your client might more than likely would get everything that you are asking if she goes to DUI court, or she can go with the statutory provisions today. Which would you prefer?
I totally understand. Ms. Ware, it's completely up to you. Would you like to move forward today?
I would like to move forward today. I
Okay,
need to get to work
I totally understand.
desperately.
Okay. All right, Ms. Ware, we're gonna ask you some questions to make sure this is a voluntary plea. And we want to make 100% sure there are some things that your attorney was asking for that would have helped you out, that more than likely you would get if you went to DUI court. Of course, I couldn't promise that. And I want to make sure you're affirmatively turning those down and moving forward with the plea today as recommended by the state.
Yes, I am. Yes, I am.
All right. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with Ms. Vigilante's representation?
Yes, I am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
Did anyone force you to take a plea at this time?
No, ma'am.
And you understand you're giving up your right to trial by judge or by jury by taking the plea today?
Yes, ma'am.
And you further understand the requirements that you are going to have to pay a fine of $2,500, complete 240 hours of community service. You're going to undergo a risk reduction course and a victim impact panel, as well as an alcohol drug evaluation and treatment, and you're not to drive. Do you understand all of those requirements, Ms. Ware?
Yes, ma'am.
All right. As to the charge of driving under the influence of alcohol and drugs, Ms. Ware, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state or the defense?
No, ma'am.
No, ma'am. Ms. Ware, I'm gonna bring you everything in writing, including my contact information and the probation office, okay?
Okay, I appreciate it.
No problem.
Thank you so much.
All right.
Hi, everybody. Thank you.
Is
for-
ACDC complete? Okay, thank you.
Thank you. Bye.
All right, take care.
We can do probation number 3 through 6, 9.
Okay. Okay, give me one moment. Pull up something.
Excuse me, Ms. Falk, I'm showing I need 4 null process in total.
Okay, let me just make sure, 4 in addition to the ones I've sent? Or
No,
4
no,
total?
no, 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 I just went
Okay.
over.
So I have sent you Justin Shaw, Mr. Salter, Minifield Brown, and Rasul Jones. Were those the 4?
So that's the 4, okay, so,
Great,
okay,
okay.
thank
So
you.
we're on track. Okay,
Mhm.
good deal. Thank you.
Okay, give me 1 second, I'm sorry. In the meantime, who do I have from probation today?
3 through 6, 9, David.
No, the officer.
Oh. My apologies.
Do I have Officer Brooks? All right,
Yes,
good morning. Thank you. Will you please raise your right hand? And will the defendant please raise your right hand as well? All right, do you both swear and affirm that the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
yes.
Sir, do you say yes? You promise? All right, thank you. What we're gonna do today, sir, is you're here because there has been we're here to see if your probation, how we're gonna deal with the alleged violation of your probation. First, I'm gonna hear from Officer Brooks as it pertains to this case. Then I'll hear from your attorney and we'll figure out how we're moving forward. Officer Brooks, please proceed, reminding you that you are under oath. Oh, and sir, do you understand your rights today?
Yes, Your Honor.
Okay.
Thank you, Your Honor. What position are we doing?
I believe we have, this is position 5, 6, 5, and 6, or he's 4, 5, and 6.
3, 4, 5, and 6.
3, 4, 5, and 6. He's 2 pages. David Nimi, I'm sorry if I'm saying it incorrectly. So he's 3, 4, 5, and 6.
Your Honor. We're here for Mr. 9, case number 23-CR00161-2A. He was seen on March 30th of 2023 for giving false information to police officer, obstruction of an officer, and another count of false information to a police officer. He was sentenced to 12 months probation, shoplifting prevention course, and to stay away from location. He last reported on April the 17th of 2023. He never enrolled in the shoplifting class. He owes $360 to probation and $81 to the victim crime fund. Do you want me to just go to the next case too then, or one at a time?
We'll do them all together if you don't mind, so that we can kind of keep tabs on what your recommendations will be. I'm writing them down. So the next one is his battery case.
And then the next case is 23-CR00161-3A, seen on March 30th, 2023 for battery. He was given 12 months probation and 8 weeks of anger management course. He never enrolled in that program. He last reported on April 17th, 2023 for that case as well. On the 1612A, he has 213 days remaining and we're asking to revoke. And on the 1613A, he has 16 days and we're requesting time served.
Officer Brooks, can I just ask really quickly? Maybe I'm missing something. My understanding is the violation was entered November 15th, which would be 104 days before the end of probation. Can you help me understand where 213 days is coming from?
Yeah, that's
I can't
His
help
warrant
you.
was told.
Yeah, and so my understanding is the warrant was issued November 15th.
Yeah,
Give me one second. Let me pull up and see if I have a copy of the warrant.
So the recommendation for position 4 is time served. And the recommendation for position 3 was to continue and complete.
No, the recommendation that I have written down is to revoke. On the case that's 612A, they're asking, and on 613A, time served.
Right.
Okay. Okay, so I'm assuming you don't object to the time served. We just need to figure out the revocation.
Yes,
Is
Judge.
that correct?
And I can, you know, maybe while we're figuring out the time left on this case, I will say, Mr. Nime was, incarcerated in Fulton County Jail from May 11th until September 11th. And so he did, you know, he was sentenced March 30th. He reported in April, then most of May, all of June, July, August, and a substantial piece of September was spent in custody. He's actually been in custody 161 days of his 12-month sentence on these two cases.
Okay. And I'm sorry, how much time remains? And what was he supposed to do originally? He was supposed to take, I know he didn't report, but how much time remains, Officer Brooks, for position 3?
According to my records, 213 days remain. The warrant was told on November the 10th.
And that's what Judge, I'm just not sure about, because November 10th would have meant, you know, the rest of November, December, January, and February, right? Because he had spent 30 days in jail when he took his plea on March 30th. So I'm not sure how that can possibly be 213 days.
Okay.
I believe it's 109 days.
Okay. And what does he have? What was he supposed to do, Officer Brooks? I'm sorry, I'm making you go in circles, but please, if you would tell me one more time.
Yes, Your Honor. On this one, he was supposed to complete a shoplifting prevention course.
Okay. All right, I'm gonna allow him to continue on probation. He has 109 days or 213 days. Either way, he has enough time to do that class. So I'm gonna order that he is allowed to continue. He must report to probation within 48 hours of his release, and he must engage in this class within 2 weeks, or at least get signed up for it within 2 weeks.
Excuse me, Your Honor.
Yes.
Can I get the proper,
I think you should speak to your attorney. Don't tell me anything. Why don't you ask Ms. Vigiletti?
Mr. Nime was telling me earlier today that he was having some difficulty figuring out how to register for the anti-theft class. He doesn't have a computer. He was trying to use his phone, but I will assist him with that.
Okay, I appreciate that. Okay, so with that order, does that conclude his case at this time, or is there anything additional?
That is it for Mr. Nime today.
Officer Brooks, is there anything else that you'll need from me?
Yes, Your Honor. What about the other one where he has the 12 months probation with the 8 weeks of anger management that they were requesting time served for?
That's fine. I accepted that recommendation. Time served to close that case. Okay? Okay. All right. Best of luck to you, sir. That is gonna conclude your case at this time.
All right, thank you, Your Court. Y'all have a good day.
All right.
Your Honor, can we go back to the regular SAP calendar and do position 38, Travis Williams?
Yes, we can.
Come on.
And Your Honor, I just have a brief announcement. Position 6, Eric Erickson is his last name. The state did ask to speak with Ms. Vigiletti and ask for a reset so that we can make a global recommendation on that case. We don't need a long reset either till Thursday or next Tuesday, but we are asking for a significant amount of jail time.
It would have to be a 1 week out, Ms. Walt.
Okay.
Okay.
And the jail time we're asking for would encompass that amount of time.
Okay, so no prejudice will result from resetting. So we're gonna reset to 4/16. Is that the correct name? Okay.
And he is position 1 on it looks like an add-on calendar was sent out, and he is position 1 on that calendar as well.
Oh, I missed the add-on. Okay.
As did I, which is why we're asking for the reset.
Okay.
It's already of the add-on is Mr. Erickson, so.
Okay, and Mr. Erickson is not at courtroom 2, is he?
He's already been escorted out. I explained to him what's happening.
Okay, long as he's aware. Okay. All right, we're at position 38, Mr. Travis Williams, is that correct? All right, Mr. Williams, your case is 24 CR 001441E. You're charged with simple battery. Do you understand your rights?
Yes, ma'am.
All right, the announcement that I have is that this is a negotiated plea. Is that correct?
Yes, ma'am.
Well, not you. Don't you don't answer. Mr. McLean, is that correct?
Yes, Your Honor.
All right.
Oh, I'm sorry, this is Travis?
Yes.
Yes, this is an unnegotiated plea, that's correct.
Or a non-negotiated plea. So
Right.
in light of that, Ms. Tyson, can I have the history, please?
Yeah, that's on the announcement list, right?
I'm sorry, I might have read it incorrectly. I just saw plea and got excited.
24 arrest cycles beginning in 1995. There's 2 felony convictions outside of the 10-year period. I'm sorry. One for purchase, possession, control of drugs, that's from 98. The other is for violation, Georgia Controlled Substance Act, that's from 98. Did have a felony case out of Fulton County for manufacture, sale, dispense, or distribution of drugs. He received first offender treatment on that case in 2001, and the case was sealed in 2018. Let's see. I'm sorry, he has some additional felony convictions outside the 10-year period. He has another out of Fulton County for manufacture, sale, dispense, distribution of drugs. That's from 2002. He has 2 counts of aggravated assault out of Fulton County from 2002. And he has another purchase, possession, control of drugs. And that's from 2004. He has a more recent felony conviction for aggravated assault out of Fulton County. That's from 2018. And his last arrest was in Fulton County, and that was for aggravated assault as well. His position date on that case is November 8th of 2023. And he received 7 years probation on that case. And it appears he has, let's see, 5 federal arrest cycles. Last arrest was in 2018, and that was for a violation of probation. And it looks like he had time revoked, 24 months revoked on that. Let's see, he has a felony conviction from 2009 for assault and a 2006 bank robbery and a 2006 bank robbery. Nothing to add, Your Honor.
Pretrial, did you cover the 2023 conviction for aggravated assault? Maybe I didn't hear it.
Yeah, that's the one that he has the probation for
Correct.
7 years. Yes. Mm-hmm.
Right.
Mm-hmm.
And he also, Your Honor, had a conviction under 17 SC 153994. That was not only for aggravated assault, which was a conviction in 2018. It was also for a family violence battery, simple battery, and a simple battery that was pled down from a sexual battery. So that is important because of the facts of this case, Your Honor. The facts on this case are on March 26th of 2024. The defendant entered onto the MARTA at 5 Point Station. Miss Ceresia Clems stated the defendant had followed her, harassing her for an extended period of time, made unwanted physical contact with her hair and shoulders, and stated she was being verbally harassed by him and that she did want to press charges due to the behavior of this defendant. The state's recommendation on this case is 12 months served 60 days, credit for time served 14 days. That is from March 27th of 2024 to today. Balance probated, no further contact with Ceresia Clems. That is Cereisia. Clems, CLEMS. Stay away from all MARTA and 40 hours of community service. We did have an opportunity to reach out to try to reach Ms. Clems. However, she is not going to be present today. We did request that she be alerted to this hearing and asked her to call us back. And the state's recommendation is due to his prior aggravated assault convictions as well as to the nature of the cases that were pled down to the simple battery and aggravated assault. And based on that, in his fairly recent history with that 2023 and 2017 aggravated assault charge that he pled guilty to, we are asking that to be the recommendation of the court, be the state's recommendation. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
For said purposes, we do so stipulate.
All right. Mr. McLean, why don't you give me your recommendations?
Your Honor, the 12, the way we put these three numbers, the 12, 60, 14, actually it'd be 15 days, I believe, from the time that he got arrested. So that would leave him 15 extra jail days to go if the court went with the state's recommendation. And he simply wanted to ask if it could be less than that at the court's discretion, all the way down to 0 extra days and go home today, or a lower number than the 15. That's it's simply a matter of he feels that he has heard everything. He knows that he is under an obligation to do this correctly, and he feels that he could do that just as correctly quicker than 15 days from now. He feels a certain amount of there's an air of danger, and people are concerned about events.
Okay, in light of information before me, if he takes the plea today, I would accept the state's recommendation and he would have the additional days. Does your client want to take the plea, Mr. McLean?
Let me ask him, Your Honor. I'll go on mute for a little bit, and I'll stop, if it's okay to stop video.
That's fine.
There we go. Yeah, we went all the way. Your Honor, he would like to accept, looking at the realities, Your Honor, in the unnegotiated plea, I guess, in a sense, he'd like to just turn it right back into a negotiated plea.
All right. Then you did so stipulate to the 3 elements, correct?
We did.
All right, Mr. Williams, please raise your right hand. I'm going to ask some questions to make sure this plea is in fact voluntary, all right? Do you swear and affirm the testimony you give today be the truth to the best of your knowledge under the penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time? Did anyone force you to take a plea today? Did anyone promise you anything in exchange for taking a plea?
No.
And you understand that taking a plea, you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you're further giving up your right to have a trial by judge or jury. And you understand the requirements that you're gonna have to complete 40 hours of community service and have no contact with Ms. Clems upon your release. You also must stay away from all murder. Do you understand that? All right. And let me see. Oh, and you understand that taking a guilty plea may affect other aspects of your life that either your attorney or I may not be able to anticipate, such as employment or immigration. Is there any in light of those instructions or in that information, do you still wish to take this plea?
Yes.
All right. As to the charge of simple battery, Mr. Williams, how do you plead?
No, sir.
I accept your guilty plea. Is there anything additional, Mr. McLean or Ms. Falk?
We can't think of anything, Your Honor. Thank you.
All right.
No.
Best of luck to you, Mr. Williams. That concludes your case.
Your Honor, I do have a request on Chavis Smith, which is the 1, 2, 3, 4 cases. Well, 3 cases, 28, 29, and 30. The state is asking for more jail time than Mr. Chavis is currently served. When I went back and looked at the bind over, what's not jumping out at me is the amount of jail time he served on the two cases on the calendar at East Point. And so if Your Honor, the state could ask for just a 1-week continuance so that Mr. McLean can present me with any information as regard to the jail time he served on those cases so I can figure out how much time he'd be entitled to.
There was no
Right
time
now,
served offer on
can't
any of these?
I went
Okay.
through the bind over and I can't find it. It may be because I'm moving fast, I'm not sure, but I can't see how much time he served on each of the 2 cases previous to the last case.
Okay. And I just want to make sure he doesn't have any time served offers on the table today. That said a week would not prejudice him. Mr. McLean, any objection to the reset to next week's SAP?
That works, Your Honor, because it wouldn't cost any extra time anyway.
All right, and he is booked in on all of these. He didn't make bond on any such that he's not accruing time, correct?
Let me just
I just
double
want to
check
make sure because
that issue, Your Honor.
if he's sitting
And
in
he's
time,
right, and he's not accruing time. I
right?
understand.
That
Let me
will
just
that
double
might-
check on Mr. Smith.
Okay, thank you.
Well, she doesn't want to do that.
Okay, so no, he is in jail on all of these charges. Theft by
Okay.
shoplifting, the public drunk, the loitering, the criminal trespass, and the disorderly. So he is accruing this time on everything.
All right, we will reset position 28, 29, and 30 to 417. Is there still room, Ms. Grace?
Yes, Judge, just do room.
Yes, Judge.
Okay, so we're gonna reset those. Thank you. Okay,
And Your Honor, I do have another request.
yes.
Mr. Walker is here to cover the last, I think there's like 5 more cases on the calendar. Beyond this one, he is
You
going
want to
to cover-
leave us, Ms. Falk? Is that what's happening? You want to go eat
Mr.
lunch and leave the rest of us to starve?
Definitely not eating lunch. Mr. Gamage is calling me. I had another meeting that was scheduled to start at 12 with the state
Yes.
court judges, and so I'm already a little bit late to that.
Go ahead, Ms. Falk. Have fun. I got the short straw, so I don't get to go to that meeting today. So take care. We like Mr. Walker, so we're happy to see him step in. All right. We still have the probation calendar, but we only have 5 left on SAP. Or is it completed courtroom 2? Oh, okay, we're on mute.
Good afternoon, Judge.
Hi, Mr. Walker. Always a pleasure to see you.
We have 1 from probation and 1 for the regular county.
Okay. We have announcements for the other ones?
We have to get that chair. Mr. Williams, Mr. Williams, we have to go to the back.
Judge, were you asking for announcements on other clients?
I was asking because, well, we have other parties to take, so let's go ahead and proceed. What case can we take next at courtroom 2?
Position number 11 and 12 on the probation calendar.
Yeah, that'd be good.
Okay. Okay, we're taking up Shannon Ryder.
Correct.
In this case, you're charged, the underlying charge is 22 CR 00710 In that case, you were charged with driving under the influence and speeding. And then, of course, you have the violation itself. Officer Brooks is still under oath. Will you raise your hand, please? Do you swear and affirm that the testimony you give today, for the limited purposes of dealing with this probation matter, will be the truth to the best of your knowledge under the penalty of perjury?
Yes.
And you do understand your rights today?
Yes, ma'am, I do.
All right. Thank you. Officer Brooks, please proceed.
Thank you, Your Honor. He was seen on April the 20th, 2023 in front of Judge Ed Line for DUI less safe and speeding. He was sentenced to 12 months probation. He was sentenced to 240 hours community service, the risk reduction course, the victim impact panel. My apologies. And he had a revocation hearing on June 13th of 2023 that he failed to appear at, and then the warrant was placed.
Okay. And your recommendation?
The recommendation for him is to continue on probation.
Okay. Did he do any of this?
He has not completed anything, and he also has a court fine balance of $14.96 and probation fees of $80 and VCF fees of $18.
Okay. And how much time does he have left on his probation? Will he have time to complete these?
Yes, he will have time to complete the probation. His
Okay.
warrant was told on 6/13/2023.
Okay. Okay. I'm assuming you don't object to continuing on probation to complete the requirements, Mr. McLean?
No objection, Your Honor.
Okay, so sir, I will report this as a violation. You are getting a second chance to complete the requirements. You must report to probation within 48 hours of your release. And I'm gonna expect that you get started with these requirements within 30 days. All right? All right, best of luck to you. That will conclude this matter. Is there anything additional, Officer Brooks or Mr. McLean?
Nothing I can think of, Your Honor. Thank you.
Your Honor.
All right. All right, is that the balance of the probation calendar? Are we not gonna have any of the other positions brought today? Is there an announcement?
Position number 1 through
1 and 2 were released, Judge.
Okay,
Wait, I'm sorry, is this the regular calendar or the probation?
this is the probation. I was just trying to finish it,
Okay,
because they said there was only one left on the probation.
okay.
All right, 1 and 2 was released. We took up 3, 4, 5, and 6. Was position 7 and 8, 9, and 10 released as well?
No, I believe I saw him this morning.
I'm sorry?
you guys resetting him? O'Malley Thomas? That was Mr. McLean's client.
What happened to Mr. O'Malley?
I'm sorry, Judge, that's Mr. McLean's client. I'm not sure what happened there.
Mental health referral.
Mr. O'Malley is being referred to mental health.
Okay.
Yeah, that case was reset from last week.
Can we go in?
calendar.
This is the one we asked for the breakout. Can we go into that breakout really quick to find out what happened here before we reset that?
I'm sorry,
They
Judge.
wanted to break out, Judge.
On the phone with another client, and I believe he has the information.
Okay, so we have to come back to that. Well, we need to go into a breakout on that one though before we conclude the calendar. So Officer Brooks, you can't leave just yet.
Yes, Your Honor, but I wasn't clear on what you said happened with position 1 and 2.
They said that party was released.
Released?
Yes,
That's what
he was released to another facility.
To another hold, I guess.
Another agency has a hold on him as well, and I don't know the details of when the jail decides to do that, but he was released to another hold, so I suspect he will be coming back.
Okay. Where was he released to? Do we know?
On the paperwork, it says foreign agency hold with pending charges.
Okay. So someone who decided it was more serious than here, but we're gonna go into a breakout on that other one. Okay,
Sorry,
so,
Judge, he was a loan out from he was a CP, he was over in a CPO for DeKalb County Sheriff
Okay.
Department. So he was loaned out to Fulton County. And
So
now he's
he will
returned
be
back.
back.
He returned back to there with the charge pending. So I don't know how you guys gonna get him back.
Okay. I'll tell him
I don't know either.
I'll give him
Okay. We'll figure that out in a moment. Okay, there's somebody left at state all purpose. Can we take that person?
Yes, Judge, this is position 7, Mr. Taji Gatson. And I believe Ms. Gatson's mother, Cinquetta Bond, is here as well.
Okay. All right, Mr. Gatson, your case is 24 CR 001360E. In this case, you're charged with criminal trespass, obstruction, and assault, simple assault. Do you understand your rights?
Yes.
All right, I'm sorry. What is the announcement for this case, Ms. Vigilante?
Yes, Judge, so we announced the possibility of a non-negotiated plea. And I would request either to stop the recording or perhaps for everybody necessary to be put in a breakout room, because we do need to discuss some sensitive matters.
Okay, we'll go into the breakout to see if that's necessary, but let's hear the history first. Ms. Tyson, if you're still with us, can you give us the history for position 7?
Yes, one moment.
Your Honor, can I speak after she finished?
We'll see. We're gonna see. All right.
Thank you.
We have 8 arrest cycles beginning in 2014. Looks like he has a pending case out of DeKalb County for burglary in the first, burglary in the second degree, criminal attempt to commit a felony, and so a total of 3 counts of burglary in the second degree. The position info on the GCIC states that the case was accused January 21st of 2022. Let's see. It looks like he has another felony case out of DeKalb County for looks like 4 counts, 6 counts of burglary in the second degree, and 1 count of criminal attempt to commit a felony. He received first offender treatment on that case in 2016, and he was sentenced to 5 years confinement and 5 years probation. There is no seal date on that case listed on the GCIC as of yet. He does have a felony conviction, another felony conviction out of DeKalb County for disorderly conduct, terroristic threats and acts, simple assault. Disposition date on that case is June of 2022. And he received 2 years confinement, 2 years probation on that case. He has a total of 3 violations of probation, and his last arrest was March 21st of 2024, and that was for a criminal trespass, willful obstruction, and simple assault. Yep, the case that's on the calendar, Your Honor. I apologize. And it looks like he has some cycles out of Pennsylvania. He has 2 cycles out. Yeah, 2 cycles out of Pennsylvania. Last arrest was in 2019, and it looks like that was for out of state. It says probation or parole warrant. And its first cycle was in 2007, and that was for simple assault, aggravated assault, robbery, and receiving stolen property. And it looks like he might have been a juvenile at that point.
Okay.
Yes.
All right. Miss Vigiletti, do you have a laptop or something so we can go into a breakout?
We've actually purposely put Mr. Gadsden last so we can put all of courtroom 2 in a breakout. We are alone here.
Okay. But whoever Mr. McLean's on the phone with, that's not ideal.
He's off the phone.
Okay. All right. Not ideal. Again, I usually like to speak outside the presence of the defendant too. All right, if we could put courtroom 2 into a breakout with Mr. Walker, myself, and Miss Lewis, of course, will need to come in.
Miss Grace, I got you.
Miss Lewis, Miss Grace.
Okay, I got it.
And Judge, the deputy has offered to pull Mr. Gadsden out for a moment if you'd
Yeah,
like.
just for a second. I
Okay.
think sometimes you can speak freer.
Sure. Okay. And if Ms. Bond could be brought into the breakout.
Well, we'll bring her after I speak to you all first.
Okay.
Melissa, you have to put yourself in there. How you doing? Alyssa, do you need, somebody in the breakout room? Ms. Baum, I'm about to put you in a breakout room. You're gonna get a message. Please click on it to let you in.
Okay. Okay, everyone, thank you for your patience as we went through that breakout. Ms. Bonds, are you still here?
Yes,
Ms.
and
Bonds?
can I say something?
No, I don't want you to say something back on the record. What we
Okay,
would have to go. Okay, go ahead. What would you like to tell me?
I just forgot that I do have a family friend that does work with um people that come out of jail and have resources. That's what I want to tell you.
Okay, we are going to reset Mr. Gatson for 2 weeks to do some further development on this case. Ms. Bond, if you would speak again to Ms. Vigiletti and really work to find him a placement in 2 weeks, I think that that would be helpful. We're also going to order that a social worker be sent to do some further development to find a proper placement. And then we're going to take this case back up. So we are going to reset this matter. I know that Mr. Gasson is anxious to resolve it, but we want to resolve it in a way that will ensure success. So we are going to reset this case to the calendar on 4/23. All right?
Okay, thank you.
All right. And if you would take some steps and make some effort there, we would appreciate it to try to find him a placement. Okay?
Okay, I will. Thank you.
All right. Thank you. All right. We still have to talk about Mr. O'Malley. I forgot about that before we left that breakout. Can we go back there very quickly?
Y'all should be able to go back in the room. The room is, no, I have to put y'all
Still
back in the
open?
room. No, it's not open. I closed it. Let me put y'all back in the room. Who you want in there, Judge?
I guess Ms. Brooks needs to come. Mr.
Okay.
Walker may need to be there as an observer, and Mr. McLean at courtroom 2. Is everything okay at courtroom 2?
Don't lie. Don't lie.
Yes, Your Honor.
I didn't mean to introduce.
There's a conversation at the back door, that's all. Here we go.
Okay, we have completed the probation calendar, so Officer Brooks can be excused. I believe there are some positions that we did not complete on state all purpose, but as we review the calendar, I'm assuming Mr. McLean can give us those announcements. Or Ms. Vigiletti. I'm assuming that everyone either was released or there's gonna be a reset for cause requested. Officer Brooks, you are excused. We've completed probation. Miss Grace, will you please review the calendar for me?
Yes, ma'am, I'm ready. Position 1 and 2 on the add-on calendars will be reset 4/16. Position 1 on the regular was a plea. Position 2 reset 4/11 SAP. Position 3 reset jail jury. Position 4 was a plea. Position 5 reset jail jury. Position 6 reset 4/16 SAP. Position 7 reset 4/23 SAP. Position 8 reset 4/16 SAP for a global plea for his other cases. Position 9 and 10 reset jail jury with an amended bond order. Position 11 reset 4/16 SAP. Would that be correct, Mr. McLean? Because it was showing he was not brought over for you to interview.
Yes, I have 1 week reset.
Okay. Position 12 reset 4/16 SAP. Position 13 and 14 were pleas, along with position 15 and 16. Position 17 and 18 was a plea, with position 18 being non-pros. Position 19 was a plea. Position 20 reset jail jury, amended bond order. Position 21 reset jail jury. Position 22 was a plea. Position 23, 24, 25, 26 were pleas, with 25 being non-pros. Position 27 was a plea, which is a non-pros. Position 28, 29, and 30 reset 4/16 SAP. Position 31 was a plea. Position 32, 33 reset jail jury. Position 34 reset jail jury. Position 35 was a plea. Position 36, 37 reset 4/16 SAP. Position 38 was a plea. Position 39 reset further notice. Defendant was released. Any questions, concern, or comments?
Before we go, I'm sorry, on the probation calendar, position 1 and 2. 1 and 2 we didn't do because there was a release to another jurisdiction. Where are we resetting that case? We're just reset further notice, or what are we doing with that one?
Because that's going to be reset further notice on to unless probation issue out another warrant to bring him over. I don't know how that's gonna work because he left on pending charges. So he
So
was
he may
transferred
come
on pending
back at
charges.
any, so he may come back at any time.
He may,
and
but we
then-
don't know when. So
Okay.
it's just a probation violation. So it'll be something that probation will have to check in to see where he's at DeKalb County if they want to see if they can get him back over.
Okay, so there's nothing we can do with that. All right, well, I believe we have concluded the SAP. Oh, I'm sorry, were you saying something, Ms. Vigiletti?
Yeah, so we said that before we left today, we would know how to deal with Ratangela Neal, position 22, her felony FTA issue.
Oh, that's right. Ms. Falk was looking into that and she's left us.
No, I got a solution. It is going to be taken care of. We had a long extended conversation with pretrial services, and they are working on a withdrawal hold for that case as we speak. So it will not hold her up.
So that's something I'll sign, or they're gonna?
No, it has to be a superior court judge to sign, since it was a superior court judge that signed the warrant, and the warrant was over in superior court area, and it was a superior court FTA. So no, they will have to sign it. So it's nothing on you, Judge.
Okay, can we make sure, please, that all paperwork? Oh, go
We're
ahead.
making sure that paperwork is being done as we speak for the FTA.
Okay, so if I sign but I'll still sign the plea paperwork.
Oh,
Okay.
yeah, you'll sign the
Yeah.
plea paperwork. You just want to deal with the FTA because it's not one of our case numbers. It's a felony case number.
Okay.
Can we please
Understood.
make sure all paperwork is sent over, as soon as possible, mainly the bond orders, Mr.
And the
McLean,
null
Vigilante,
price, please.
and the null process. I have those, Judge, and I'm gonna send all of that to you now.
Okay, I will get
Okay.
to sign it and I will send those right back. Thank you all for your patience today. I know that this calendar has been long and it's been difficult. If we at all possible can, I know that there's a lot of strain on the public defender's office, but if at all possible, if we can try to maybe start our interviews a little earlier so that we don't hold the calendar. I know that's asking a lot. I know you guys do a lot and I'm very grateful for all that you do. And I know it's difficult to
If
do
I
the
may-
interviews ahead of time. Of course.
We've been getting our recommendations, and Ms. Falk has told us she knows and she's on it. We have been getting the recommendations the afternoon before. So Mr. McLean and I are here until late into the evening, the day before.
All right. So Mr. Walker, you've heard that. If we can get our recommendations slightly earlier too, that would be wonderful. So that we can all enjoy our SAP lunch. All right, everyone. Thank you for all your hard work as always. This was not a critique by any means. It was just a slight request. Take care. We'll see you all soon. I'm not on this calendar for a while, so I hope to see you, some of you all on SCA in the future. Bye-bye.
Thank you.
Okay.
Have a good one.
Mainly.
Judge, are you with us this afternoon? Okay. All right.
You'll have Judge Law. Bye-bye.
Listen, you could have stopped the live feed.